Loading. And we're in.
Okay. Good morning. We're going to call to order this public hearing of the General Law Committee, 9:33 on Thursday, February 25th. Just start with co-chair, Representative D'Agostino. Do you have any comments? Okay, he's ready to get to work. Representative, the ranking members, do either Representative Vitigliano or Senator Witkos have any comments?
Ready to proceed, Mr. Chairman.
All right, thank you, Senator Witkos. And with that, let's call the first speaker today is the Commissioner Siegel from the Department of Consumer Protection. Sam, is she in?
I just arrived. Thank you.
Okay. Good morning, Commissioner Siegel.
Good morning. Yeah, it's always interesting. You never know if somebody's in the room with you.
Yeah.
Thank you. Good morning, Senator Maroney, Senator Witkos, Representative D'Agostino, and Representative Vitigliano, and other members of the honorable members of the General Law Committee. I want to thank you for the opportunity to testify this morning in support of Senate Bill 694 and House Bill 6099. These were requested by the Department of Consumer Protection, and we appreciate the committee's consideration of these proposals. I also have some comments and suggestions on Senate Bill 895, which generally we support as well.
They that they have details in a maps as opposed to the agency.
If everyone could just make sure they're muted, please.
A little bit.
Hey, Representative Hayes, you might want to hit, there you go.
Thank you.
Thank you. Overall, these bills are making a number of changes to our pharmacy and drug control statutes. Many are technical or aimed at streamlining our work. A few others provide some additional tools to protect public health and safety. There's also some suggested changes to the medical marijuana statute to address M&A activity and the more recent legalization of hemp manufacturing. But with that, I think the details are all in our written testimony, which I won't repeat, but I'm happy to answer any questions.
Great, thank you. Do any of the members have questions? Senator Witkos.
Thank you, Mr. Chairman, and good morning, Commissioner. I have some questions regarding Senate Bill 895, in particular, the section on the self-dispensing of machines for syringes. And I read through folks that had submitted testimony already, and kind of some of the things that they made statements in their testimony I didn't see in the bill, and I think it needs to be part of the bill. For example, one of those written testimony said that right now they can get 10 per week, but sometimes the clients use 10 per day. And I noticed the bill says 10 per transaction, but we don't limit the number of transactions. So somebody could go in and do 5 or 10 transactions a day and get 50 or 100 needles. So I'd like to see a cap put on that. I don't know what the cap would be, but I'd like to hear if you have any thoughts on that. But I honestly think there should be a cap on that. But secondly, the language says that they can put the used syringes in a securely safe, locked container. And the language in the bill does not provide that. The language, it says, or in an area around a secured machine. So that, to me, could be simply just a garbage can. If it's in a vestibule that's open, so anybody can grab those. So I'd like to see that language tightened up. If you care to comment on that, and then I just have one other question.
Okay. No, we're happy to take a look at both those issues. This was not actually an initial DCP proposal, although we did work with kind of stakeholders and were supportive of it, but we can look at sort of placing the cap. I do think the disposal, it is intended to be secure, just creating a little flexibility on where that could be, but we can certainly look on how that could be tightened up.
Okay, and the last thing I had, it's totally unrelated, but since you're here, I've heard folks' concerns about for methadone clinics, the hours is very, very restrictive, where somebody can go and get the medication that they need. anecdotally, I'm hearing like 5 a.m. to 8:30 a.m. And if they can't get it from at that particular time, they got to wait till the next day, or they've got to go to a different facility to try to get some there. Why do we control if we do, I don't know if we do or not, control the hours in which a patient can go get their methadone? If we're going in the direction of allowing access to syringes out of a dispensing machine, why are we not loosening up the hours that methadone could be distributed?
I would have to look into that. I don't know if that's something that the Department of Consumer Protection is doing, but I'd have to double check on that.
Check in my district in the city of Torrington is where I'm hearing the concerns. The dispensary is, you have appointments between 5 a.m. and 8:30 a.m. and then that's it. And so I just have some concern. But and I don't know if it's their own set hours, but I heard rumor that it was set by DCP. So if you could just check into that for me.
Yeah, I mean, we don't control those hours, but we can look into why they maybe think that we are kind of limiting them and see what that's about.
Okay, thank you. And I'll work with you on the language to tighten that other section up.
That would be great. Thanks.
Okay, great. Thank you. That's all the questions I have, Mr. Chairman.
Great. Thank you, Senator Whitkos. Are there any other questions? I don't believe I see any other hands raised. So I guess seeing no other questions, thank you very much for your testimony, Commissioner Siegel.
Thank you. Have a good afternoon.
You as well. Okay. Mr. Clerk, next, I believe we have Michelle Lucan and Nicole Lake from the Office of the Attorney General.
Mm-hmm. And they're in now.
Great. Thank you. Good morning, Nicole. Are you going to start, or is Michelle going to start?
I'd like to start if that works for you.
Oh yeah, that works. So if you'd proceed, thank you.
All right, thank you. Good morning to everyone, to the chairs, ranking members, members of the committee. Very nice to see you all. Again, my name is Nicole Lake. I'm Chief Counsel to the Attorney General, and joining me this morning is Assistant Attorney General Michelle Lucan. Michelle leads our privacy section, and we're here today to talk about two bills. First, very briefly, I just want to express our office's support for HB 6099. So this is an act concerning antitrust issues and the palliative use of marijuana. This is our friends at DCP's bill, but it contemplates using our office just to make sure that proper notice is given when there are material changes to ownership between dispensaries and producers in the medical marijuana market. As you all know, I know you know a lot about this program. There are very few licenses, not many producers or dispensaries. And so when ownership is happening, there is a great chance that you could see consolidation happen very quickly overnight. So this bill really just requires that notice go to our office, and then our normal and standard antitrust review process would kick in. So expressing support for that bill. And we also wanted to talk to you a little bit this morning about SB 893, an act concerning data privacy. We are thrilled that the committee is taking up this issue. I know it is one that has been brought before the General Assembly many years running now. We believe that our office is the correct place to place enforcement. We already do a lot of work around privacy, and you've heard from us earlier about data breach notice, and you've heard from Michelle about some of those details. And this bill would really expand the protection that consumers have and give enforcement authority to our office. And now I'll give you all my caveats. We do have concerns about how this bill is structured currently. And I will start by saying we are very hopeful that we'll be able to work with the bill's sponsors and with the committee to find language that will work, allow us to do our job as enforcers, fit well within our statutes, and really give consumers the protection that they need and that they deserve. So you have our testimony. It is lengthy. I hope it is easy to read though, and we can certainly answer any questions. And Michelle is here as an expert. I'll just raise kind of three broad principles that I draw your attention to. One is the mechanics of enforcement. We would ask that CUTPA, so the Connecticut Unfair Trade Practices Act, we would ask that that statutory language be imported into this bill. It's important because it allows for civil investigative demands, which is akin to a subpoena. It allows those to be issued when you're doing an investigation, as opposed to jumping straight to a lawsuit, which then takes you down a discovery process. It's really helpful to be able to do an investigation on the front end. As you know, that authority actually rests with Commissioner Siegel and the Department of Consumer Protection. So, it would be the classic setup of us borrowing that authority from our good friends at DCP to do that work. But the second reason that adding CUTPA in here is very important is that it allows for more flexibility in terms of penalties. Currently in this bill, there's a $7,500 maximum on the statutory penalty. We would ask that you use CUTPA instead, which allows for discretion. It also would allow, and an example of that, let me give you, is ability to pay. And some penalties should be smaller, some potentially should be greater. CUTPA would also allow for injunctive relief if we were in a situation where that was appropriate, or allow us to seek injunctive relief. So the enforcement piece is one, and I think the primary issue that we would ask you to look at. There are other changes that we would like to see in the bill, specifically the exemptions or carve-outs. We think that they're a little too sweeping here. It gives some carve-outs to entities as opposed to the information that they maintain or hold. So we would ask that it be focused in on the information as opposed to the entity. The right to cure provision is something that would hamper our ability in terms of enforcement power. And we also would prefer an opt-in, so that the consumer opts in to sharing their information as opposed to opting out. And then just finally, I'll say that, resources are always something that we have to consider when looking at taking on new enforcement work. We also think that education is an incredibly important component of this, helping consumers to understand what their rights are, what their avenues of redress might be. And we take our work to be not just around enforcing the law, but helping the people of the state of Connecticut understand what their rights might be. So, that's a conversation for down the road, but we'd flag that. So I'll stop talking, and if there are any super technical questions, again, Michelle is here as a privacy expert and could answer any of those. Thank you.
Thank you, Nicole. All right. Are there any questions before I go? Because I'm going to ask some questions, but let me see. Okay. Let's start with Representative Cheeseman, and then Senator Whitcomb, and then Representative Luxemburg. So Representative Cheeseman.
Thank you, Senator Maroney, and thank you for being here today. Question, I'm looking, first about the opt-in stipulation. So explain to me how that would play out. I'm the business, I have this data or whatever. How would I ensure before every single transaction that the person opts in? So can you just explain the logistics of that to me, please?
Sure, and thank you very much for giving me an opportunity to be here to answer questions. Like Nicole said,
thank you for coming here today. So
thank you for having me.
Yeah.
My name is Michelle Lucan. I head up our privacy section in our office, and privacy has really been a focus for the Attorney General for quite some time. We are one of the only offices in the country to have a dedicated privacy section that does this work. So I just wanted to echo very quickly before answering the question, Nicole's comments on how excited we were to see this bill raised and how supportive we are of it. So long as we can make sure we could have a structure that allows for us to meaningfully enforce the law and really does provide these rights to Connecticut residents that we all should have. Logistically, for an opt-in structure, the difference is that instead of placing the burden on the consumer to exercise rights over their personal information, the burden would be on the company to make sure that there's some kind of mechanism that they can provide for us to opt in to sharing our personal information. So it's you'd have to take an affirmative step to authorize.
Sure, I get that, but maybe, and you know, I read the bill. So I'm, you know, I have an interaction with a company where I'm using my credit card to purchase something. Before I make that purchase, do I then have to click another box? Or, you know, I suppose that this is someone looking at it from the business point of view. What are we doing, you know, in terms of making this work for the consumer, but also not, you know, and maybe I look at this and say, oh, I don't want to have anything, you know, explain to me. I mean, I'm in very granular detail how, if I'm the business, how I'm going to do this before any interaction with the customer starts.
I guess it would depend on the nature of the transaction and what information is being collected. So I think it would vary depending on, you know, the nature of the collection of the data. So it's a difficult question to answer just offhand.
So let's just say it's a purchase using your credit card.
Mm-hmm.
So before I do this, by the way, do you agree for me, you know, me to have this credit card information on record before you even make the purchase?
Well, so in that scenario,
I suppose my question is, what would be classified as the personal data which would require this opt-in provision? Let's phrase it that way.
So the way that we'd have to look to the bill, and the way that the bill defines personal data that would be encompassed under the law currently is pretty broad. It's any information that could be used to identify you. So, and in that scenario where you're making a purchase,
that could be your address and your name.
In that scenario where you're making a purchase, you know, you're proactively providing that information to the company. And so that is a different scenario where information is being collected from you and about you, where you're not necessarily aware of it.
Okay, so there would be a bright line between those two. And I'm looking at the section as I attempt to revive my iPad, that it dictates persons that conduct business in Connecticut or that produce products or services to residents or control process their personal data of at least 100,000 Connecticut residents or control or process, so on and so forth. Do we know how many companies this would be or businesses this would be?
We don't, and that is actually one of the concerns that we had flagged in our testimony, which is that, there have been consumer privacy bills introduced in California and now other states. And one thing that we need to make sure we do is get the threshold for application correct. And so that is something that we have flagged that we think should be reviewed further, because it would take some more work to truly figure out if that is an appropriate threshold, or if it would just accept too much of this data processing that should be covered under the bill.
Right. I mean, it could cut either way. Either
Right.
way. And without knowing what that level is, it's difficult to make an informed decision, obviously.
That's absolutely correct.
Okay. All right. Those are my questions for you. Thank you. And thank you, Chairman Maroney.
Thank you, Representative Cheeseman. Senator Whitcos.
Thank you, Mr. Chairman. My question is for Nicole. Is there, when we're talking about, this is the first bill, antitrust issues, is there a plateau or a bar where the company or the principals, if they're looking for acquisition or mergers, that they would know that don't even bother pursuing it because we would have reached that? How do we establish what that is? I know it probably on a business by business, case by case basis, but is there a standard out there that you guys would follow?
That's a great question. As I think everyone knows, antitrust law is one of the more complex areas out there. There is no set percentage that triggers a finding of market consolidation. And really what you have to look at is defining what actually concerns a market or comprises a market. So it's not always just everything in the state. When you look at the map of where dispensaries and producers are right now, kind of the Litchfield County area, you don't see many there. So what is a market in that part of the state might be very different from what you see in New Haven. So we would do that analysis and try to see kind of where consolidation might kind of go to a place where it ultimately becomes anti-competitive. And it's always with an eye to what a consumer is able to access, and whether or not prices are going to be held artificially high or occasionally low, and how that will impact the consumers. So, we do that review. Our antitrust lawyers are incredibly smart and very well practiced in doing these types of reviews. And because the overall market is smaller, we think that the review can be done without needing any additional resources within our office and can be done in a timely fashion.
I know that the bill speaks specifically to the marijuana industry, but would there be any case law that happened in the state similar to antitrust that would be somewhat precedent setting that carries over from industry to industry, or that's really not particular?
Yes, we would look at kind of broad antitrust principles and what constitutes anti-competitive behavior. And I'd be happy to follow up and send you kind of the broad principles and outlines on how we would do that evaluation, if that'd be of interest to you.
If it's in layman's terms, that would be definitely of interest to me.
All right, I have some that even involves like equations that are, if you think in math terms, I can give you that too.
All right, great. Thank you. Thank you, Mr. Chairman.
Great. Thank you, Senator Whitcos. Representative Luxemburg.
Thank you, Mr. Chairman. And thank you, Nicole, for being here. Quick, I just had two questions. One is on the antitrust issue related to the marijuana industry. It's my understanding that the current law, you could potentially have more dispensaries than we currently have. And if I'm wrong, I could be corrected. I think we currently have 4, but I think technically current law would allow us to expand that up to either 8 or 10. And so I'm wondering if that's something that's been contemplated by the AG's office or DCP or perhaps the governor's office, to sort of use what's an existing law to expand the marketplace. Because I'm assuming only having 4 total is part of what's creating the concern as it relates to competition. So I don't know if you have any thoughts on that.
Yeah, so good morning.
Good morning.
I would guess you're talking about producers instead of dispensaries there. So, dispensaries are where the consumers go in and make the purchase. Producers are producing the product. And you are right, there are fewer producers than dispensaries. With respect to the number of licenses available, I would defer to Commissioner Siegel and DCP to get you those details. I'm actually not familiar with kind of the breadth there, but to your larger point, the market is small at this point, or the number of licenses that are out there working right now is small. And that is one of the big reasons, or really the driving reason as to why we have concerns about potential market consolidation in a way that would be harmful to consumers.
Yeah, that's right. Through you, Mr. Chair. I meant the producers, but I think there's an understanding, that the current number of producers being small, they're gaining certain competitive advantages from being in the marketplace already, which may even heighten those competitive concerns. So I appreciate where you're coming from. One question about the privacy department, just to understand it better in the AG's office. How many attorneys work in the privacy area? And is it like a huge staff of lawyers? Is it small? I'd love to just get a sense of what that department looks like within the AG's office.
Well, you have 1/3 of the privacy department with you today. It is our smallest department. We have 3 members. We had 4, but our other member moved over actually to lead our antitrust department due to a retirement. They are small but mighty. And one thing that I think really is very important for the committee and for the General Assembly to appreciate, as Michelle mentioned, we are one of the only AG's offices in the nation to have a dedicated privacy unit. Michelle is a national leader in this work, as are her colleagues, Anya and John. And the work that they do, particularly multi-state and leading privacy work throughout the nation, is really extraordinary. And so, as you can imagine, when we contemplate adding in a whole other area of consumer protections to the work that they're doing, the resources concern is top of mind for us. But I'll just reiterate again, it's work we want to do, and we look forward to taking on the challenge.
Yeah, and if I could just make one final comment through the chair, I mean, I think that in itself is really interesting for the committee and the public to understand that, and perhaps it's an interesting window into, some of the ways the infrastructure and bureaucracy of government hasn't always shifted to meet, sort of our modern challenges as a society. I mean, privacy issues are sort of dominating the legal, business, and consumer spaces across the country. We've got sort of a national leader of a privacy department within an AG's office, and it's 3 people. I mean, it's really kind of a shocking, in some ways, thing to understand that, for the entire state of Connecticut, there are 3 attorneys working in this absolutely critical area. And so I think, I guess I'm sort of giving you a platform to piggyback on the resource allocation issue. That doesn't seem like a a 21st century allocation of government resources to have 3 attorneys working on something this important and complex. So I just want to thank you for your testimony, and also thank the chairs for their leadership in this important policy arena.
Thank you very much. And I can assure you that the Attorney General appreciates that highlighting. So thank you.
Thank you, Representative Luxemburg. Are there any other questions? Let me see from the other members. Okay. Well, looks like I'll start asking my my questions then. If we can just go first, highlight, I guess, the resource issue in terms of what are additional resources that may be needed. Are they all attorneys, or would there be other staff that would allow us to kind of leverage the use of our attorneys that may not be, would it be possible to use paralegals or others, or do we need more privacy attorneys?
I'll jump in quickly and then turn over to Michelle. I think the answer is all of the above.
Okay.
The work that an attorney can do obviously is going to be different than the constraints around a paralegal. However, in this bill, one example is that a consumer can appeal the use of their data to the AG's office. Were that to survive and remain in the bill, fielding all of those appeals is work that could very likely be done by a paralegal, and then ultimately reviewed by an attorney. So we are digging into this very question and trying to think in very concrete terms about who could do what work, but we anticipate it requiring a mix of skill levels. Michelle, I don't know if you had anything to add on that piece.
That's absolutely correct. So Nicole highlighted the appeals process. That's something that's on our radar. Nicole is right. This could be done by a paralegal or a consumer resolution specialist, but would need to be overseen by an assistant attorney general or several. And then also, I think we would receive complaints under the law, even outside of the appeals process, that we would need to be ready to field, in addition to the current workload of complaints that we are already responding to on a daily basis. And then just from an enforcement standpoint, this would be significant for us to be able to have this law be meaningful and to really be able to protect Connecticut residents. We need further resources to be able to really respond to the law and make sure we are enforcing it.
Okay, thank you. I guess another question, Michelle, probably, well, either Michelle or Nicole, I guess I shouldn't assume. What are the advantages? One of the things we hear is that we should wait for the federal government to act. And I do understand, the argument that it really, a lot of it is a federal issue, but the federal government hasn't acted. And, we are now seeing some states start to act. What are the benefits of having a law? If we waited for the federal government, would we then need to clearly define your authority under that? Or if you could just speak to some of the benefits of having a state law.
Sure. One of the most important benefits is that state attorneys general can be nimble. We can respond quickly to these privacy violations, including violations that may be on a smaller scale nationally, but have a really strong impact in our state in Connecticut. We do this work in a lot of other areas where there are existing federal laws in a space, but we have complementary state enforcement authority under those laws, and it benefits Connecticut residents without a doubt. You know, we do this in the health privacy space under HIPAA, and you know, I just think a law like this protecting Connecticut residents would be really important, but equally important is our ability as you know, the state to be able to enforce the law to protect Connecticut residents.
Thank you. I think one of the things we need to look at is, the interoperability, right? In that if different states have different laws, and you know, for national companies, how are they able to comply? And I think that one of the keys for that is just in our definitions and aligning definitions with other states. But given that we would be one of the early actors, right? There are a few states who have gone. How do we? Would we need to re-legislate to ensure interoperability, or with the federal, or is there a way to give flexibility within the law? It's
a really good question. I think this law in some ways does provide that flexibility. You know, we've compared it with the California consumer privacy law, including the new law, CIPRA, and some of the provisions in that law, you know, set forth specific methods for how to offer opt-out rights, whereas this law requires that those opt-out rights be provided, but doesn't provide as much detail about the actual mechanism for doing that. So I think in some ways, this law is flexible and could create a lot of consistency for companies trying to comply with the law. I think there probably, you know, we do need to look more closely just to make sure there aren't any other areas where that flexibility should be implemented. And I'm sure, you know, that the stakeholders paying attention to this will raise those issues. And I think from our office's perspective, that is something that's always on our radar too. We do want these laws to be ultimately, at the end of the day, something that companies can comply with, you know, that are trying to do the right thing. Right. So I think in some ways this flexibility is built in, and there is on interoperability with California's law and some of the other proposals that we've reviewed in other states, and that maybe there's some areas that we need to look at a little more closely to make sure it doesn't create a barrier or any further burden on companies trying to comply.
Right, and I think that that's right, in that it's a difficult balance, right? And I think we look, you know, as elected officials, I guess, you know, our ultimate customer that we're trying to protect with this is the consumer, right? And we're looking from a consumer protection standpoint, but, you know, we also want to make sure that businesses can operate and that we have a growing insurance tech industry, hopefully health tech growing, and just technology in general in the state. So we don't want to necessarily be burdensome or signal that we don't want them, because we do want them and we want more of them here. So I think that, you know, making sure we are working with them to have strong laws that protect the consumers, but also allow them to do their work. Can you give examples? I know we were going through before, you know, an example of what opt-in would look like versus opt-out, but I think, would it be possible to give an example of how someone's data may be used without them knowing it's being used? Like in the example where you're going to a store, you know you're purchasing something, right? So you know that they're going to have some, but I think sometimes people may give away their information and not realize that they're giving away their information. And I don't know if it's a fair question to ask you, but if you could provide an example, I think that would be helpful.
I think it is a fair question, and a good example that I could provide. And just speaking for myself as a consumer as well, you know, there have been many times when we're looking at something and it is very surprising the amount of data that companies have on individuals. So, you know, a good example is companies in the data broker industry, and how much information is being processed and shared. And then another example is for targeted advertising. So this is information you've shared at some point for some purpose, and is being used to send direct ads your way. And, you know, some people would be fine with that. Some people would like receiving these targeted ads and would opt in to receive targeted advertising. And then some people do not like it, and should be afforded the ability to opt out from receiving them.
Yeah, and I think that, you know, as a small business owner and in marketing, I think the amount of, and you're right, it's a balance, right? If you think of it as a marketer, it's fantastic that I can target my ads to people who have a certain income, live in a certain area, have expressed interest in certain things. But as a consumer, sometimes it is frightening to know how much people actually know about, you know, my behaviors online and what I like. And I think there was an article that was interesting about just using the data that, and the coupons that are mailed to you, right, that they're targeted. And that I guess there was I can't remember if it was Minnesota or whatever, but the father found out that his daughter was pregnant by all of a sudden the coupons that were coming in that were targeted based on their purchasing behaviors. So, and again, we understand, I guess, data is the new gold, they say, right? And so there are important uses. I think they talked about before, and it definitely is used to improve a customer experience as you go through websites or other things. But also, I think, how do you protect that privacy? Just going to the definitions, if you don't mind, can you give an example of what a processor is? So, you know, as it's in, I think this bill, controller would be, for the most part, would be the business. Am I correct in that?
Yes.
Okay.
Yes.
And so can you give an example then of what a processor would be?
Yeah. So I guess any separate entity that a controller provides your information to, and that does something with that data. So the definition is broad. I have it up. It says any person that processes personal data on behalf of a controller. So this could be for many purposes, including analyzing the data. I guess the definition is broad. So.
And so just, again, I'll use a personal example. So I have a website, and on my website, I utilize Google Analytics.
Mm-hmm.
Right? So in that definition, would I be the controller and Google Analytics would be the processor?
That's right.
Okay. And the same as I use what's called, you know, the Facebook Pixel. And so that, again, for advertising. So Facebook would also then be considered a processor, but I would be the controller. Is that?
That sounds right too.
Correct. Okay. Now, what would a third party be?
Yeah. So I guess any entity that received that data downstream. So I'm scrolling to the definition to see what the exact language is. Yeah, right. Any entity other than the controller or processor in this bill structure. And there are scenarios where data does get passed downstream beyond a controller or a processor, which is another one of those areas we've sort of flagged for further review. You know, that the stream doesn't stop at the processor and the controller.
Right. So, again, I guess I'll use myself as an example, in that, so I provide a service for other businesses where we can help them run reports, right? And so they send the information to me, and then we send the report back to them. So would I be a processor, I guess, in that, or a third party?
That is a good question. You know, I don't know. I mean, I guess we'd have to think on it based on what processing activities are occurring. But
Right.
there could be scenarios where an entity is both. And I think there's also a provision in here sort of recognizing that what shoes a company steps into is a fact-specific determination that also has to take into account all of the different companies that are involved with that transaction. So.
Right. So, thank you. And the other thing you mentioned before, like, data broker. And it's not part of this, but I know that there is, Vermont does have a data broker registry. Have you been in contact with their Attorney General's office to find out how that has worked for them? I know that this past March, I think they processed, or they had the first violation against that they did convict, or that they went after. So.
Yeah, so we have really good relationships with our sister states and talk very frequently with our colleagues in attorneys general's offices around the country, including in Vermont. We speak to our colleagues in Vermont regularly. We have spoke about Vermont's data broker law. And I know that Vermont, they've been busy, I guess, following up with data brokers that should be registering in the state and haven't, and also starting to enforce the law and really push the protections offered in the bill. So we've spoken with them, and I imagine that is something that will continue. And then also the data broker registry in Vermont is something that is available, for other states to make use of now. So it is something that it's an example of where one state passes a law that benefits other states right from the get-go.
And onto the size of the entity, you mentioned we may want to try to, I guess, lower our thresholds. And I know, so this is in line with Virginia, which is also in line with the proposed federal Consumer Online Privacy Rights Act, that, a company that processes 100,000 pieces of data, and then there's the size. California is lower, right? It processes, I think, 50,000. I'm not sure if they had changed it. That was in the original. I don't know if there were changes in separate. I haven't reviewed that. But do you have any, I guess, suggestions on what is an appropriate threshold, or do you think that's something that would need to be fleshed out? And I guess since California has been in place, we can get data on how many companies are encompassed by that.
Right, that's right. Yep, I think this falls in the category of we don't have a specific suggestion. We want to make sure the application of this law is appropriate. I know Virginia did raise a threshold that matches this, but there have been other state proposals raised that do have a lower threshold. To your point from earlier, we also think interoperability and consistency is something that's important too, so that should also be considered. And then I think you're right that this could be something worth reaching out about to find out if California in particular has any color that they could provide to this, and how I guess just how it has gone with the rollout of the CCPA. So I think we'd have to review it and discuss it further. But from our office's perspective, we just want to make sure the threshold is appropriate and it's not too high to dilute the effect of the law in our state.
And I think you cited Maine and Virginia, which Maine and New York. I'm sorry. I'm not as familiar with their legislation. Do you know their threshold size? I mean, obviously I can look that up after. I'm being a little lazy now. I do have access to my good friend Google, who can point me to their legislation, but I've gotten used to being spoiled by having a legislative aide who I asked to look all these things up for me. So
I do know that the Virginia bill matches this threshold. I do know that.
Okay.
And so the others I could look up, but I don't have it offhand. So.
And I know, similar to Virginia, we do have the date is pushed out for when this would go into effect in January 1 of 2023, which would give us, assuming this is passed and signed into law, time to study it, and then I guess potentially, if necessary, make changes, before it goes into effect. And I do believe that is what there is a working group that was proposed in Virginia. Is that something you would recommend we would add here, a working group? And can you talk to that?
So as Nicole said, we do have some concerns with the language as drafted, but we do think there is a really good chance that with discussion and collaboration, we can resolve those concerns. So I do think, and we would be happy, we would love to participate in that, to contribute. I don't know what appropriate forum that should take,
Right.
but I do think those types of discussions will be important for us to make sure we're comfortable with where the language ends up. So, and I don't know if Nicole has anything to add on that, but I think the further discussion and collaboration is what will be important to us, whatever that forum is.
Yes, I would amplify what Michelle just said, and also say that our office certainly would never speak on behalf of industry out of turn, but
Right.
my understanding from talking with stakeholders who are would be impacted by this bill, my understanding is that they would very much welcome the opportunity to collaborate, troubleshoot. I think to Representative Cheeseman's kind of to the spirit of her earlier questions, what does this actually look like on a granular level? And, to your point, Senator Maroney, which category do I fall into here? Am I maintaining? Am I processing? I think having the voice of the regulated entities in the conversation is important, in addition to our voice as, the enforcement agency. And, I think that really is a good way to put together law that will be very workable. And that is really our ultimate goal. So we would be very supportive of, a study, a task force, whatever you want to call it. Maybe don't call it a task force.
Yeah, I'm not I like working group better than task force, with emphasis on working, right? Making sure we're actually getting together and doing the work. So
Yes, absolutely. And we would welcome the opportunity to participate in those conversations.
And, so I guess another question in terms of definitions where people would fall. The House yesterday passed a law providing some tax incentives or incentives to data centers to locate in the state. And again, we have the growing tech. We're hoping to grow an industry of the data centers. How would this law impact any potential data centers that were located here? Now, would they be, I'm assuming that, are they processors, or how would the data center itself fall within there? It's more of a tool, I would assume, or is there no impact at all?
I think there would be an impact. I guess it would depend on the nature of the information and the thresholds whether they meet the thresholds in the law. So it would be something you'd have to, like I said before, take a look at the specific facts to determine the application of the law. But just based on the nature of the activities that they're performing, I think they should come under the law. So it would be surprising if they didn't.
Right. And so if we are to put together a working group, I think it would be good that, we obviously would include technology companies, but I think including these data centers representatives would be helpful as well. I think that's all I'm going to ask you for now. I will, if I think of anything else, I will ask it, and I will reach out. But I believe Representative Ackert has a question now. So I'll turn it over to Representative Ackert.
It's very surprising, Chairman Maroney, that I could have any questions after your complete breakdown of this bill. So I appreciate that work and the answers. But I'm going on the fine component of it. Before I get to that, how does somebody reach out to you to log a complaint? Is it somebody they just go to the Attorney General's office and say, listen, I feel as though my data has been used inappropriately? Can you just do a Reader's Digest? And for people know what Reader's Digest is actually, right? Review of the how that process works for me, please.
Sure. So our office does have a complaint portal right on our website. We also have an email that consumers can use to send complaints our way, and they can call us anytime. And so for our office, when we receive those complaints, we review them and make sure that they're forwarded to the appropriate section to review those complaints. So for our privacy section, we get complaints about data breaches all the time. We have Connecticut residents reaching out to us very regularly, asking what they can do to protect themselves from data breaches or what steps they should take in response to data breaches. We get complaints about privacy violations. And so our section reviews those. We respond to Connecticut residents. We make sure we assist them as best we can. And then when circumstances warrant, we also reach out to the companies that the consumers are complaining about to try to get an answer from them and address the underlying issue.
Okay. And then at that point, if you feel as though it's pursuable for a fine, then you get into, and it looks like I see some like investigators or something along that line, and you review the issue. And then if they don't correct it, and or you feel it's a finable approach, because I know that Nicole brought up the fining component of it, and it does say up to $7,500, so it's not an automatic. But if that process, that these fines could actually go over the $7,500 threshold, possibly if they're that egregious.
So not under the language of this law, the $7,500 statutory fine would be a cap. But one of the things Nicole mentioned at the outset is that we've asked for to align the provisions of this law with our Unfair Trade Practices Act, which frankly does provide a lot of tools for us to use so that we can really flesh out a violation. So, not every complaint that we receive to our office results in a full-scale investigation. But sometimes you do need to send a civil investigative demand, which Nicole said is like a subpoena, to really wrap your mind around what is happening. And it's important to have that first step so that we don't, immediately need to file a lawsuit. And, the only ability we have to gather that information to really figure out where does this issue lie in the grand scheme of things would be through civil discovery. And under CUPPA, our Unfair Trade Practices Act has a similar penalty scheme where it contains language saying up to a certain amount. It's $5,000 per violation. But CUPPA's, a law that has been around for a long time, and there's really some strong case law in Connecticut addressing penalties issued for violations. So, it's something, if we align it with CUPPA, we'd really have a lot more tools to use to be able to review potential violations before having to go full steam ahead. And then we'd also be able to look to our existing structure to make sure whatever redress we seek, whether it's injunctive relief only, whether it's injunctive relief and penalties, is something, and so that we have the full, I guess, realm of our enforcement discretion, and we can make sure the redress actually matches the violation and is appropriate and fair.
Thank you. Thank you.
You're welcome.
That's fine if, that company's fine. Does the revenue from that go to the AG's office, or does it go to the general fund or wherever?
It depends. So if under, it depends. We have some privacy laws in Connecticut that direct penalty towards our privacy guarantee and enforcement fund. But for the most part, the laws don't prescribe a specific fund, and the penalties end up going to the general fund. So, we've announced a lot of, a number of really important settlements for consumers' privacy over the last several years, including in Equifax and Uber and Home Depot and Anthem. And so it will depend on what claims are raised in those cases. But for the most part, the penalties that we've recovered under those cases have gone towards the general fund.
And that's why I see in section 11 of this, the Attorney General may recover reasonable expenses. So you might not get that financial support if that stays in there. So in terms of getting more people on board to help with this, I'll listen to more dialogue. There's not a lot of people testifying on this bill, but one of the things that we want to make sure is that we are balancing. We got to make sure that we protect our consumer, but not, negatively affect a potential business, that we're in here negatively. So I don't think that your office does that, but I really appreciate this. It's really helpful. Now I know where to direct people. I have to call the Attorney General's office, so I'll know, and we'll work on the staffing part. But thank you so much. Thank you, Mr. Chairman.
Please feel free to send them our way.
Thank you, Representative Ackert. And yeah, I actually did have a constituent email about a privacy issue, so you will be getting an email probably fairly soon. I do see that Senator Kissel has raised his hand. Senator Kissel? You're muted, Senator Kissel.
I was just trying to be quiet. Good morning, Nicole and Michelle. You've done an awesome job. In a previous hearing, I spoke to my good friend, the Attorney General, who he and I served together for a number of years. And I related that I felt like I'm the victim of identity theft. And here's the weird scenario, and I just don't know if you guys can help me out or where you can direct me to, but I had like 3 credit cards, and I started to see mysterious charges popping up on those cards. So for like a year, I kept calling them and getting them erased. But eventually, being a legislator, I got so busy that when they would send me a new card, I would just put the FedEx envelope on my dining room table and not even open it. And all of a sudden, without being activated, there were charges being put on those cards. So I eventually wrote to those banks. They're major banks. They're not small. They're like Chase. And I said, just close these cards out. But I feel like I'm getting ripped off. It's been a while, but I don't know if you guys can help at all. But it's sort of along the lines of personal information being disclosed that I don't know what's going on.
So I think that's exactly the type of issue that we handle in our office and try to help individuals with. And I'm sorry to hear you experience that. I'm sure it's terribly frustrating, also alarming. I think it sounds like you've taken some steps already. It is confusing why this would keep occurring. But so what we would do is try to make sure we give you every resource that you would need to make sure to take steps to protect yourself, including your social security number. And then it can't ever hurt to ask for an explanation to say, you know, why did this happen not once, but twice or 3 times? And why are these happening for cards that haven't been activated yet? I don't know the answer, but that's exactly what we do. And we try to mediate those complaints. So when I say respond to it, I don't mean, you know, a full-blown investigation, but we would reach out and try to make sure you and we could have a better understanding about that type of pattern and why it's occurring and what we can do if anyone else comes to us experiencing a similar issue. But again, I'm sorry to hear that you're experiencing that, and that is well within our wheelhouse, and we would be happy to help if we can.
So Michelle, can you send me some contact information and I'll send you the list of the 3 banks? And
Sure.
and again, this is something I raised with the Attorney General already. And he actually texted me and said he's looking forward to coming before judiciary and da 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 da. But when you say it's frustrating, oh my God, when you don't activate a card and all of a sudden there's like $1,000 now put on that card, it's like, what is going on?
Right. And
Yeah.
first and foremost, you shouldn't be responsible for any of those charges, but there are things that you can do outside of contacting your banks to let them know this is happening, to try to prevent this from happening again, including, you know, credit freezes, placing fraud alerts on your credit files, and I can make sure to send those resources to you.
I really appreciate that, and I'm sure you have been in, or you can easily get in contact with Kate McAvoy, my legislative aide, and I'm sorry for being very personal about this, but I've been listening all morning and you guys are on the ball. So I figured don't let an opportunity pass without trying to help stop this nonsense from occurring. Because to me, it's just criminal robbery just over the internet.
I will make sure that everyone gets connected, and we'll see what we can do, Senator.
I really appreciate that, Nicole. Thank you, Mr. Chair.
Thank you, Senator Kissel. I apologize. I do have another question now. Something did
I let
come
you
up.
in.
Yeah. So you mentioned the Privacy Guarantee and Enforcement Fund. So we have an existing non-lapsing account. I know that is one thing that I have seen in a lot of the other states, that they do create that fund and direct any penalties to go in there. But we do already have that Privacy Guarantee and Enforcement Fund in existence in the state. So we would not need to create that with this legislation. Is that correct?
Yeah, so our position would be, it's always helpful to have flexibility, you know, to direct the funds where they should go. And we do have our Privacy Guarantee and Enforcement account. But, you know, it's set up in a very specific way. And there are a lot of parameters around the account and how those funds could be used. I know the Virginia bill did set up a consumer privacy fund, and the language is a little confusing with respect to what the fund is set up for and how the monies placed in the account should be used. I think our current structure under CUPPA works really well for us because we have that flexibility to make sure we're directing the penalties in a way that makes sense. So I think maybe the Virginia Consumer Fund could have been a result of, you know, specific issues for Virginia that may not necessarily cross over to Connecticut.
Right.
And we do currently have a good structure under our CUPPA law. So.
Okay, thank you. And I believe California had done that as well. And we didn't have that initially, right? Not to be too restrictive. And I think you are right that flexibility is better. But it also brings up another point that even though we may need additional staff, which I guess would be a fiscal note, it's also potential that they will be generating additional revenue, right? In that, I think overall the Attorney General's office recovers a substantial amount of money during the year. Is that, I mean, it's possible that you're more than earning your keep, as you said, small and mighty, right? The three.
Small and mighty. And I did mention some of our recent settlements, like Equifax, which had a $175 million penalty back to the states for data security failures, and Uber, which had a $148 million penalty back to the states for breach notice failures. And so you're right. We do, when appropriate, we have sought penalties to which I guess benefit the state, but also offset the resources that we use to investigate these cases. And that's something we're always mindful of, which is another reason why our multi-state work is so important. It's another way we look to offset those resource constraints. And it's only 3 of us in our section, but we have a really good team of colleagues from across the country working in this area, and that's another reason why we've been able to do such good work in this area.
Well, thank you. And I promise this will be my, I'm not going to promise. Okay. This might be my last question unless I think of something else. But you mentioned multi-state work. Have you been in touch with the Virginia Attorney General's office, and are there any recommendations? I guess it's hard though, because it hasn't gone into effect yet. So it may not make sense it's so recent there, but there probably aren't many lessons learned yet. So I guess it's not necessarily, I guess maybe it's not pertinent since there are probably not lessons learned at this time.
I think one thing we try very hard to do, because we talk to our sister states so frequently, is just make sure other states have on their radar what privacy legislation is raised. So we are aware of the Virginia bill, and we, just as Virginia would, we would make our colleagues aware of Connecticut's bill and what the terms are, because they're doing, the same exercise in their own states. So definitely aware of it. We do talk to our colleagues very regularly, including in Virginia. And I think, since I guess that will continue depending on what the result is in Virginia and in our state and in others.
Okay.
One thing. Oh, sorry, Senator. Just the one thing I would add in there is that, looking to the Virginia bill, this language before you now is very similar to what was originally raised in Virginia, but it has undergone many changes kind of in their amendment process, and a lot of the changes that they have added in have been kind of in a similar vein to what we are seeking. So making it align with their enforcement structure, making it align with their kind of their consumer fund, and having it be more specific to Virginia state law. So, to the extent that you are looking to sister states, would just point you to kind of where that legislation is currently and the changes that it has undergone, similar changes that we are seeking here.
Great. Thank you, Nicole. That's an excellent point. So are there any other questions? I don't see any. So with that, thank you very much for your testimony today, Michelle and Nicole.
Thank you.
Thank you.
Okay. Next is Kent Owusu. Mr. Clerk, is he in the room?
He's coming in now.
Okay.
He's in. He just needs to unmute. There he is.
Okay. Hello? Yes, and I apologize.
I'm having some issues.
Okay, would you like us to come back to you or? Okay, Mr. Clerk, why don't we bring in Dr. Gregory Shangold, and then we can go back to Mr. Owusu.
Okay. So yep, next is Dr. Gregory Schenkel. No.
Okay.
Can you hear me?
Yes, Dr. Shangold, if you would proceed.
All right. Good morning, Senator Maroney and distinguished members of the General Law Committee. I'm Greg Shangold, the president of the Connecticut State Medical Society. On behalf of the physicians and physicians in training of the CSMS, I thank you for the opportunity to provide testimony on Senate Bill 895, specifically the changes to subsection J of the Connecticut General Statute, beginning on line 441 of SB 895. The Connecticut PDMP collects patient-specific data on various controlled prescription medications and enables physicians, prescribers, and pharmacists to access this information. The PDMP is a valuable tool to improve patient safety and health outcomes. As an emergency physician, I often have incomplete information when making healthcare decisions. The advent of the PDMP has helped bridge that gap. Additionally, I've seen the ravages of the opiate epidemic from the front line. Medicine and society have to rethink our approach to the opiate problem in order to decrease the number of deaths from opiates. One of the important steps has been to remove the stigma traditionally attached to opioid use disorder, or OUD. There are multiple medications to treat OUD. Two of the more common are methadone and buprenorphine. Methadone is dispensed at an opiate treatment programs. All of these OTPs are required to obtain certification through SAMHSA and then therefore federally assisted drug programs. Currently, buprenorphine prescriptions are visible in the PDMP and methadone is not. Historically, federal law specified that federal assisted drug abuse programs were not permitted to report methadone dispensing. And there's certain rationale for that reasoning. But in 2020, SAMHSA indicated that this regulatory scheme was no longer advisable in light of the current epidemic. The omission of OTP dispensing data from a PDMP can lead to potential serious consequences. Patients may receive duplicate or potentially contraindicated medications, therefore placing them at risk. Additionally, OTPs are not open 24/7. So some patients, when they're in the hospital, are unable to get prescribed doses until the medication can be confirmed when the clinic is open. So we acknowledge the privacy concerns with submitting this data. However, the dispensing of data does require the patient consent on the front end. We ask that this committee support Senate Bill 895. As physicians caring for patients in Connecticut, it is critical that we have access to the most robust patient information. The omission of this data prevents physicians from obtaining that updated information. It's vital for our care coordination. Please support Senate Bill 895.
Great. Thank you very much, Dr. Shangold. Are there any questions? I don't see any hands raised.
My hand
You know,
raised.
I'm sorry, Representative Vitigliano. Representative Vitigliano, if you would proceed.
Thank you, sir. Thank you, Doctor. Okay, hold on. I really appreciate you coming out and testifying in favor of this. I believe it's an important tool in the toolbox to against the opioid crisis. And there was a little pushback from the Department of Consumer Protection, and I didn't know if there had become any agreement to get around that. I think it had to do with inpatient care in the prescription monitoring program. Am I stating that correctly, Doctor?
I believe so, but currently none of the inpatient medications, whether they're morphine, Vicodin, are reported if they're dispensed in the hospital during in-hospital treatment. So methadone wouldn't be any different at that point. So I didn't really understand that part of the pushback, because and hospitals don't dispense medicines necessarily to go. That's part of it.
Maybe they were talking about inpatient rehab, possibly. Could that possibly be their concern?
That might be their concern, but again, if there needs to be some technical language, we're open to that sort of agreement. I think the biggest part of the methadone is those that are getting in the clinics. I could tell you yesterday, that instant happened. A patient was in the emergency room for 2 days. We had given him his methadone. The methadone clinic had reported him as not receiving those doses. And if we had better coordination, that could have been cleared up a lot easier.
I appreciate that. Doctor. Is there any other, I'm trying to use the word properly, methadone type medications that aren't reported now? I mean, substitutes for opiates and heroin when people are trying to get clean and trying to improve their life, that maybe should be included along with methadone in the drug reporting system?
So buprenorphine is in the system, and methadone and buprenorphine make up the two most common medications that are used. There are some other ones. There's some like long-acting injectable medications that they may receive at a clinic. So that might be appropriate as well, but that certainly makes up a much smaller percentage of the medication-assisted treatment that are in the tool bag there.
So just to be clear, if we had to make a minor adjustment and maybe exclude certain inpatient treatment centers, that the importance of getting methadone in the reporting system outweighs even just taking that out, and you would still support that?
That's correct.
No, I really appreciate you testifying today, sir. Thank you for your time.
Thank you.
Thank you, Mr. Chairman.
Thank you, Representative Vitigliano. Dr. Shangold, 895 has, I guess, several changes, in addition to this change. I was just wondering if, and you may not be ready to comment on the others, so I apologize. We could always circle back to you, but one of the things we do look at is, authorizing use of automated prescription dispensing machines in nursing homes. It's my understanding that they are currently utilized in hospitals. So I think for some of us, trying to visualize what that is exactly, if you could just talk about that, and I don't know if you'd have if you would have a position on that, but if you're an emergency room physician, I'm assuming that you can describe them better to me than I'm imagining them as now.
Sure, and I can't speak specifics to the modifications, but in general, an automated machine. What some go by the brand name Pyxis, but I believe there's other companies that do that, where a pharmacy sort of pre-stocks these machines throughout the different floors and areas, so that when a medication is ordered, a remote pharmacist can review that medication, and then it's authorized to be pulled out of this machine by the nurse. And many times the nurses count those medications, and that way the nurse has it, rather than say an old style where it's coming from a central of physical pharmacy within the hospital. I think that's what you're referring to with these automated systems.
Okay. Yeah, and again, I think that helps us just to see, just to visualize what it would be like. I think, it's not, so it does help in terms of giving like personalized dosages for those patients, and it kind of limits contact. Is that because it's not coming from a centralized system out there? It's been preloaded. Is that safe?
Yeah, so just safety culture and high reliability. It's always good for doctors' orders to be reviewed by pharmacists to make sure of interactions and appropriate dosing, especially with children. And some rural hospitals don't have on-site 24/7 pharmacists, but they might have a remote pharmacist that then can review that order and then release it, and then there's that medication, and they stock them on the units for the medications that are most appropriate for that particular unit.
Okay.
So I think these do contribute to a safe culture within the hospitals.
Great, and so you would. Then that would extend to within the nursing homes as well. You think they would help with the medication safety and ensuring limiting the number of hands that touch that, which I guess limits the potential for mistakes in dosages or contamination of some form, I guess, as we're in the COVID era.
I suspect so. I've not been in the nursing home, but it also provides safety, especially with controlled substances, that there's specific counts and they can easily audit who goes into those bins and helps control those, but while making these medications available when needed. So I think in general, the use of them is safety. I can't speak to the specifics of how this bill modifies the current practice.
Okay, great. Thank you. Representative Tigliano, is your hand up again, or is that?
Mr. Chairman, your questions prompted another question, and if you would indulge me, I'd like to ask it. He may have just answered it just now, but if somebody else needed to go first, that would be fine.
No, you can proceed because I'm looking for another piece of language I want to ask a question on. So you'll give me a second to do that.
Doctor, while I have you here, I may have missed a conversation with DCP earlier in the public hearing. I had a dual meetings going on there a little bit. Are these unattended machines that you're referring to, like a vending type machine?
And they're really the ones I'm thinking of. And again, I assume what I'm thinking of is what you guys are asking of. But for instance, in the emergency department, it's a sort of a computer with locked drawers, and they're all linked into the hospital system, so that when I enter an order, say I want lidocaine to suture a patient, I type in an order for lidocaine. The nurse then goes to the dispensing machine, which is linked into there. A pharmacist has reviewed my order, and then that will
electronically reviewed your order.
What's that?
Electronically reviewed your order?
Correct. They're not sitting there in the emergency department. They're wherever they are in the hospital system, and they're saying, yeah, that's an appropriate medication. Or lidocaine might not be the best example, but if I order, some person's blood pressure medication, but then they'll say, is that the right dose? Especially if it's a child, like you prescribed accidentally too much. And so then they make that medicine now releasable so that it can be taken from the machine. If not, they'll call me and they'll say, fix it.
Authorized to be in those machines?
What's that?
Are pain medications, or even maybe opioids or anything like that, really the stronger pain meds authorized to be in those vending machines?
They are in those machines, but there's a requirement that a nurse actually verifies the count each and every time. So every time a person goes in there, so if they stock, say 15, and they don't overstock them, but say they look at the utilization, they say there's 15 tablets and I order 2, the nurse is going to say, yes, there's 13. And then there's continuous audits, and then they can see where the count is off. So that they do identify misuse in those situations.
All right. So just based on your professional opinion and what you do for a living, you're comfortable with that system when it comes to those serious medications in a vending machine?
Yeah, I believe the safety measures they had, I mean, in 18 years, I think I can think of 2 nurses in the 18 years that were identified as, and I'm not aware of all of them because these are private HR matters, but word gets around. And so it's been relatively safe. And then when they do find these mismatches, they're able to address them. On the other side, not having these available in an emergency department that runs 24/7 when you do need medications to give out to patients, the alternative, there's sometimes a medicine not stocked, that a unique medicine, and it does impact patient care when that's not available. I would, the safety, I believe, is there, and I think the alternatives are much worse.
I appreciate your answers and your time, Doctor. Thank you, Mr. Chairman.
Thank you, Representative Vitigliano. And actually, I think Dr. Schengold, you just brought up a good point that, hospitals have on-site pharmacies. Nursing homes do not. At least I don't believe there are any. There may be some, but at least they don't all have those. So this would increase then the availability of medication if it were needed. And it seems that it would be safe, right? Because you would only be dispensed if it were prescribed by the physician, correct?
Again, I can't speak to nursing home specifics, but I suspect that a physician enters their medications, and having those pharmacy review again allows that double check on the work.
Okay. Then the other question I have, and I don't see any other hands raised, is just in regards to the portion of the bill that looks to modify the collaborative drug therapy management agreement with the physicians. I guess one of the things is removing the 30-day. I guess there's a requirement that every 30 days they would have to report. And I think from some of the testimony I've seen that sometimes they may not see someone in those 30 days. So that would be really burdensome and unnecessary to report that they hadn't seen anyone. But I don't know if you've reviewed that section and if you had any comments on that.
I haven't reviewed that section, Senator, specifically. So that one would be hard for me to comment on.
Okay, no, understood. So with that, I don't see any further questions. So I just want to thank you for your time and coming before us to testify today.
Thank you very much. Have a good day.
Okay, you as well. Mr. Clerk, is Kent Owusu in?
He's still in.
Were we able to?
He's still in. We can try again. I moved him back. I moved him as an attendee, so I'm just going to promote him again.
Okay.
I'm not there if it's for me. Just letting everybody know.
It's my good friend Amazon, I believe.
Yet again.
Yes.
All right, he's in. I do not know. Wait, here he is.
Okay.
All right. Good morning.
Yes.
Can you hear me okay?
Good. Yes, I can. Yes, we can, I mean. So, thank you.
Thank you. Chairman D'Agostino and Maroney and ranking members with Vitigliano and distinguished members of the General Law Committee. Thank you for providing me this opportunity to provide some testimonial, which was previously shared via email communication. My name is Kent Owusu, and I'm a licensed pharmacist in the state of Connecticut, also a member of the Connecticut Society of Health System Pharmacists. My purpose for joining you today is to provide some verbal testimony in support of the bill concerning changes to various pharmacy statutes, specifically, as you highlighted, Senator, the 30-day reporting back requirement for the collaborative practice agreement. In my current role, I care for patients with neurocritical illness, including patients with acute ischemic stroke, epilepsy, status epilepticus, among other neurocritical care disorders. And oftentimes I collaborate with providers, including physicians, advanced practice providers, and nurses to care for patients with neurological illness. Pharmacotherapy, as you'll agree, is integral to the clinical management of these patients in the setting, and it ultimately drives outcomes related to care. The bill as proposed does not change the pharmacist's scope of practice. Rather, it eliminates the need for an outdated administrative burden for pharmacists, physicians, and advanced practice providers who engage in this agreement that was created prior to availability of shared electronic medical records. It also provides clarification that a written protocol within the CDTM may include guideline-directed management. So essentially, we are hoping that with your consideration for removing this 30-day requirement, we will maintain the pace with technology. Limitations of this requirement is incongruent with clinical practice, and it's not considering patient-specific factors usually incorporated within the care plans for our patients. In order to improve care for our patients and also placing safety as a priority, we should strive to improve the current collaborative drug therapy management processes by removing this need for this 30-day reporting back requirement, and then really place the focus and efforts by clinicians to patients, but also ensuring that monitoring plans are tailored to the patient's specific needs. I think you highlighted a critical point earlier in your discussion with the prior physician that most patients may not be seen within this time period, so it only provides additional work without any clear benefit. And for these reasons, I hope that you guys will consider supporting this bill. Thank you.
Thank you very much. And I see on your jacket you have the PharmD, so Dr. Owusu, for your testimony. I'm going to see if there are any other questions. I do have some questions, but I like to let other people go first, so I don't need to ask them if someone else asks the question.
I must say, Mr. Chairman, it was a little difficult to understand the good doctor, but I'm guessing he supports the bill based on his written testimony. Is that true?
Yes. In support of the bill.
The changes in the bill.
And the changes, correct. So Dr. Owusu, can you just, you say it, the guideline directed management, can you explain what that is, right? And then another thing, if you could explain, well, I'll give you one question at a time. I apologize, just for our own benefit. I think that would help us, since most of us are non-medical professionals on this committee.
Absolutely, happy to. So a typical patient that a clinician may see, so in my setting, I see patients with epilepsy, while other pharmacists might see patients with hypertension. Patients' follow-up monitoring is going to be based on patient-specific factors. So for example, if the patient is controlled with respect to pharmacotherapy for an indication like hypertension, the guidelines do not recommend follow-up within 30 days in some instances. A typical follow-up monitoring for a patient that's stable could be between 3 to 6 months. If there's a requirement to provide reporting back to a provider within 30 days, first, it provides burden on the patient, but also additional financial implications that may not be intended. For patients with epilepsy, for instance, a 30-day monitoring period is not critical and it's not usual as part of the care for patients who are stabilized on outpatient pharmacotherapy. So I hope I was able to provide some examples on typical clinical scenarios that are tailored to guideline-based recommendations.
Yes. Now, one of the things that I've heard is that, making these changes would allow I guess, pharmacists to to practice more fully and I guess to their training. Can you elaborate on that? On how the current restrictions are? I guess this is one example where you're not, but are there other examples of how the current arrangement doesn't allow you to practice within the full scope of what you've been trained to do?
Absolutely. It appears that initially the requirement for this 30-day reporting was in the absence of consistent transparency within the electronic medical record. Currently, this bill limits the number of patients that a pharmacist may be able to see. So if there's a requirement to provide inherent volume related to reporting, we perhaps may not actually be able to see the number of patients that we may ultimately be able to see in collaboration with that physician. I think the limitations with this bill basically impede the collaborative practice agreements that most clinicians desire to participate in with pharmacists, and limits the ability for us to actually execute patient care in that setting.
Okay, great. Thank you very much. Are there any other questions? I don't see any. So, Dr. Wusu, thank you for your testimony, and I guess you can go back to work now. It looks like you're in front of the hospital. So, thank you for taking the time out of your day to testify.
Thank you so much for having me, and I appreciate your time.
Okay, Mr. Clerk, next is Nancy Lieben.
And I'm bringing her in now. She should be in now.
Great.
Hey, Ms. Lieben, are you in the room?
I am here, yes.
Okay, please proceed with your testimony. Thank you for joining us today.
Thank you, and good morning, Chairman Maroney, Chairman D'Agostino, and distinguished members of the committee. Thanks for the opportunity to testify today. My name is Nancy Lieben. I'm a partner at the law firm of Davis Wright Tremaine, where I lead the privacy and security practice. I was previously the Chief Privacy Officer of the Department of Justice during the Obama administration and served as DOJ's representative to an Obama White House task force that developed a framework for consumer data privacy in the 21st century. And before that, I was counsel to then Senator Joe Biden when he was a senator on the Senate Judiciary Committee, where I advised him on privacy and data security issues. My views today are informed by that experience. I'm here today on behalf of NECDA. This is an issue that's important to our members who work very hard to protect their customers' privacy, and they have a very strong record of doing so. We therefore commend the committee for addressing this very important issue. As a general matter, online privacy is an interstate and therefore federal issue that is best addressed by Congress. And for this reason, our members have long supported comprehensive federal privacy legislation that would apply uniformly to all companies and all consumers across the country in the same manner. There is bipartisan support in Congress for federal legislation with consensus around most issues, and we're optimistic that the incoming Biden administration, supported by a Congress under Democratic control, can enact such legislation. Indeed, federal privacy legislation is more needed now than ever. Since California passed its omnibus law several years ago, a patchwork of state legislative proposals with conflicting obligations has been emerging. And if passed, these proposals could increase compliance challenges and costs for thousands of companies and create confusion for consumers and businesses alike. NECDA members strongly prefer federal privacy legislation, but should Connecticut decide to enact a consumer privacy law, SB 893 is the right approach, even though this bill would in some respects be problematic for businesses. For instance, it requires opt-in consent for all processing of sensitive data. personal data and requires companies to conduct internal assessments of a wider range of activities than even the California law. These assessments would be available to the Connecticut Attorney General, and it requires businesses to monitor the compliance of vendors in certain circumstances. And finally, the penalties in this bill are stiff. But as consumer advocates said of the identical bill in Virginia, there is a lot to like about SB 893. It gives Connecticut consumers strong baseline privacy protections that they don't currently have, including the right to access, delete, correct, and port their personal data. Gives consumers the right to opt out of the sale of their personal data, the use of their data for targeted advertising and profiling. And in this way, the bill is balanced, focusing on privacy harms to consumers while allowing businesses to use data in ways that consumers demand and expect. And because it mirrors the recently passed Virginia privacy bill and borrows from the European Union's General Data Protection Regulation, it is compatible with existing frameworks, making compliance more manageable and providing consumers with predictability. And finally, as I mentioned before, the bill is backed by very strong penalties of up to $7,500 per violation. That's triple the baseline civil penalty under the CCPA. And as I noted at the outset, NECTA strongly prefers federal privacy legislation that would harmonize companies' obligations and consumers' rights across the country. Variety of inconsistent state laws will make compliance impossible, undermining the very protection that privacy laws seek to provide. Each new state law that differs from others, even in seemingly modest ways, can require businesses to make a host of internal changes and renegotiate contracts with every service provider and third party with whom they share data. In this regard, SB 893, the approach of looking to Virginia is better than what other states have done in looking to California, which is not a model for success. The California bill is not a model for success. States that have tried to copy that approach have not been
Excuse me, Ms. Libin, we're at the 3-minute marker.
Oh, I apologize. May I have another 30 seconds to
Yes.
wrap up? Thank you, apologies.
Yep, please summarize. Thank you.
Sure. So although we would typically advocate against a new state privacy law, this bill is at least balanced and interoperable with existing laws, provides strong protections. Just caution that all of that could be undone by any amendments that undermine the careful balance that the bill currently strikes. Thank you very much for the opportunity to appear here today. I'd be happy to take any questions.
Great. Thank you, Ms. Libin. I see that Representative Cheeseman has her hand raised, and then followed by Senator Kissel.
Thank you, Chairman Maroney. Good to see you again, Nancy. Obviously, you have a lot of experience both in your current position and with your work before at the federal level, including with now President Biden. I think in your testimony, you said you were optimistic that we may see some federal level legislation this year coming out of Washington, and the importance, given the, in fact, global scope of this, and certainly the national scope of this issue. How optimistic are you? And are we best placed to, sort of hold our fire until there is a federal standard?
I'll start by answering the second question first, and then yes, I think that federal legislation is preferable for all the reasons I said about the ability of companies to ensure that they can put in place compliance programs that are going to meet their obligations and protect consumers uniformly. The reason that we're optimistic is because there was tremendous progress made during a Republican-controlled Senate during the last Congress, which bodes well for getting a bill across the finish line this year with Congress and the White House under Democratic control. I would also add, I think there is sensitivity as well in Congress. You mentioned, Representative, the global imperative to address these issues. I think that it's recognized too that as an international trade issue, data flows are incredibly important, and having in place comprehensive federal privacy legislation is critical to ensuring the cross-border data transfers that are so critical to international trade. And I know that Congress is aware of that as well. Several proposals emerged in the last Congress, and we'll see some of those return this year as vehicles in the new Congress, introduced by members of Congress who are still in critical leadership positions in the relevant committees. Some of the proposals are very similar. All of them provide a coherent framework that would apply broadly and uniformly. They'd be enforced by the Federal Trade Commission as well as state attorney generals to respond to some of the concern voiced earlier about the role of state attorneys general and ensuring that they have a role to play in enforcement. The federal legislation would provide for that as well. Notably, none of the proposals adopts the approach that California is taking. So I do want to emphasize that that is definitely a framework that people are not looking to as a path to success. Some of these bills have bipartisan support, and as I mentioned, there is consensus around a host of issues, including the rights that consumers should have to access, delete, correct, and port their data. A requirement for opt-in consent to transfer or process certain types of data, carve-outs for de-identified data, distinguishing between service providers and third parties, requiring reasonable data security, and so forth. I think that one of the reasons, in addition, there's reason to believe or be optimistic this year. Tech regulation is high on the agenda of issues to be addressed by the incoming Congress. There's bipartisan support, as I said, for this issue. And finally, President Biden is a deal maker at heart. He is not an ideologue. He is somebody who is very he's a creature of the Senate who will get involved to get legislation over the finish line. And he's not somebody who will let the perfect be the enemy of the good. He'll want to get things done. So for all of those reasons, we're optimistic that something will happen.
Okay, thank you. And can we say, certainly as from your point of view, to quote you, SB 893, it may not be perfect from your point of view, or perhaps from the point of view of data privacy hawks, but it is pretty good. And because it appears again to model closely the Virginia approach, this is something with which you could live while we're waiting for that federal level regulation.
Yes, provided that it remains written as drafted today, yes. Any amendments, as I said, even modest ones, can throw the careful balance out of whack.
And obviously this is work for the committee. I've seen some real concerns voiced by the Connecticut Hospital Association and some of the other entities, but that will play out later. All right, well, thank you for your answers. Good to see you again today, and thank you, Mr. Chairman.
Thank you, Representative Cheeseman. Senator Kissel, followed by Representative Vitigliano.
Thank you, Mr. Chairman. Did you have an opportunity to listen to Nicole Lake and Michelle Lucan's testimony earlier? Because they had some suggestions for changes to the bill. And you said you support the bill, but you oppose any little changes.
That's correct. I did hear their testimony, and the reason we support the bill as is without further changes is because we know how difficult it is to strike the balance that this bill so carefully strikes. And I think you can look to looking at the Virginia bill, which is a few steps ahead of this one. Virginia, like Connecticut, it takes an approach to privacy regulation that focuses on potential harms to consumers while putting the least amount of disruption on businesses so that they can continue to provide their services and develop new ones. The Virginia bill received a claim from privacy advocates who called it a bill about which, and the quote was, "There's a lot to like." And you can apply that, to this bill too. It's like an identical bill. I think that says a lot that you've got consumer advocates and industry coming together and saying that we can live with this bill. It provides really meaningful protections that consumers don't have. If this changes, even in some seemingly modest ways, those changes can have serious impacts on the balance the bill strikes in business operations. I'll give you one example. There was a suggestion that the bill provide for opt-in consent, a blanket opt-in consent requirement to shift the burden. We and others think that that is not a good approach. The reason for that is I think it's tempting to think of opt-in consent across the board as a panacea or the best means to protect consumers. But even experienced privacy regulators like the Federal Trade Commission during the Obama administration looked at that issue and determined that a more nuanced approach was better. What the FTC came up with after spending several years of working with stakeholders and conducting workshops and talking to consumer advocates and academics was a framework that develops a spectrum of consent, allows consent to be inferred in some instances with the right to opt out, and requires opt-in consent in other instances. And it adopted a framework very similar actually to the way this bill approaches the issue. It required opt-in consent for certain uses of sensitive data, which this bill does, while allowing consent to be inferred with an opt-out right for uses of non-sensitive data, which this bill does. And it also determined that businesses should get opt-in consent to use consumers' data in materially different ways than was represented to them when the data was collected. Again, this bill does that as well. It even goes beyond, this bill goes beyond what California did in providing protections to consumers, in that this bill requires opt-in consent for processing sensitive data, any kind of processing of sensitive data, whereas the California bill, only the new CPRA requires opt-in consent when sensitive data is used for certain purposes. So, I think that using that as one example, and just referencing Senator Maroney mentioned the Target example of the father discovering his daughter's pregnancy because of coupons received in the mail. This bill would address that. This bill, as written, would require opt-in consent for the use of sensitive data like a medical condition to be used for advertising. And so, I think this bill would prevent the kind of harm that Senator Maroney referred to earlier, and that is a cause of concern.
And I just have one second question, and this is going to prove my ignorance. You stated that you work for a law firm, but are you representing a certain organization and speaking here today?
Yes, apologies if I wasn't clear. I'm a lawyer at a law firm, but I'm here on behalf of the New England Cable and Television Association.
Okay, thank you. Thank you, Mr. Chair.
Thank you, Senator Kissel. Representative Ritigliano.
Thank you, Mr. Chairman. Good afternoon, Madam. Good morning, really. I just have a quick question. When you were testifying, when you were reading your testimony, right near the end, you said that don't do the California bill, and then we sort of hit the clock. If we could just go over once again why we don't want to pass the California bill, because for some of us who are maybe learning about the topic, there's been this bill, and then there's the one that looks like California, and the talk about why we don't want to be California. So if you could just go over that or finish your thought, that would be great. Thank you.
Yeah, sure. Absolutely. Thanks for the question. Well, the California bill has been it's still evolving. And I think that speaks to how poorly thought out it was when it was initially introduced and passed 2 years ago. It was almost immediately amended upon passage. Even 20 California Democratic senators and congressmen, congresspeople wrote a letter as soon as the bill was passed and said, we need to amend this. We got some of these issues wrong. It's been amended twice. The California Attorney General has had several, multiple notice and comment periods to develop the underlying regulations, which are still changing and making it absolutely impossible for businesses to finalize compliance programs. And I know from my personal practice and working with companies to help them comply with that law, that there is so much in the way of prescriptive requirements that companies have to do a lot of things, make technical changes to their business processes that don't provide any material benefit to consumers in the way of privacy protection, but just create a lot of noise in the system, require consumers to read a lot more, get a lot more notices that provide the same information over and over, for instance, but don't particularly advance the goal of consumer protection. Whereas this approach, which is more like frankly, the European approach, is a more holistic approach based on good data governance, just good data practices. Requiring data protection assessments means that business, which California, the CCPA did not require. This approach requires companies to look internally, put processes in place, and develop good practices for handling consumer data, protecting that data, identifying risks proactively, putting in place processes to mitigate those risks, to prevent harms from happening in the first place. It's just a smarter approach that I think avoids a lot of the unintended consequences that California had. I think that California was written so quickly, a lot of people took that off the shelf and repurposed it without waiting to see how the amendment process would evolve, and realizing that bill was drafted so quickly, it just wasn't fully baked at the time.
So would you say, Madam, that the other bill on our agenda today, the SB 156, is closer to the California one compared to the one that you're endorsing, 895? Are you familiar with the other bill on the agenda today?
So I am familiar with the Senator Duff's bill, but it was very abbreviated, the version I saw. So I've not, if there is a new version of it, I have not seen the newer version.
I appreciate your time and your answers. Thank you. Thank you, Mr. Chairman.
Thank you, Representative Vitigliano. Yeah, and the other bill is subject matter public hearing, so it's a concept that hasn't been fully drafted yet. So that's, I believe, 156, SB 156. But Representative Winkler?
Yes, thank you for your testimony. So Comcast, I call up Comcast and say, I don't want them to collect data on me. And they make a mistake in coding and they sell my information, and I'm getting advertisements for all sorts of things hooked into the TV show I have been watching. And when I complain, if I understand it correctly, under this bill, the bill that you endorse, I would not have a private right of action. Is that correct?
That's correct.
And what is, the Attorney General isn't going to care. I'm the only one that's going to be upset. From what I understand, the Attorney General has the only cause of action.
The Attorney General has a cause of action, has the enforcement authority under the bill. I think there are advantages to the way the enforcement mechanism is constructed under this bill. It gives the Attorney General the right to obtain those data protection impact assessments that I mentioned earlier, that companies are required to conduct and document. And this, coupled with the right to cure, should allow the Attorney General in an investigation like that. So if you, for instance, were to call up and say that you had this issue, the Attorney General could use that opportunity to either write a letter giving them the opportunity to cure the violation, or obtain the data protection assessment if they open an investigation, and look at the processes in place to determine whether there was anything that indicated a violation of the statute. The penalties under this statute, as I mentioned, are much larger. They're triple the baseline civil penalty under the California statute. And in that respect, provide serious deterrence to companies as they go about trying to comply with the law, ensuring that they're in compliance. Even legislatures that have been very forward-leaning in providing greater consumer privacy protection, like California, have declined to provide the kind of broad private rights of action that can lead to meritless lawsuits. Not saying that in your case that would be a meritless lawsuit, but just speaking generally about the incentives, putting incentives in the right place. We think that the incentives in this bill are strongly geared toward providing consumers great protection, backed by the threat of a $7,500 per violation penalty if they don't.
Before I continue with my questions, are you saying that there is no private right of action under the California bill?
There is only for data breaches. So if there is a data breach that results in the disclosure of a certain category of information, and that breach was caused by a company's failure to have adequate security in place, in that case, consumer could bring a private right of action, has a private right of action. Otherwise, no, it's only the California Attorney General who has enforcement authority.
All right. Would it be fair to say, given the limitations on the Attorney General's office, that massive data breaches would be something that they would be interested in, but an individual who was accidentally miscoded, we'll say, or whose data was, I don't know, breached because somebody copied it and took it out of the building, those people would have no recourse. The Attorney General's office isn't going to pick up individual human beings. They're not like the Department of Consumer Protection or anything.
Well, I mean, I think that goes back to the right to cure, and I'll refer to something that the Attorney General of California said about the right to cure under the CCPA, and that is that the ability to write a letter to a company and complain about evidence of a violation or a complaint that they'd received about a violation had a tremendous impact on getting companies to act quickly to solve problems within the 30-day period. And if the objective here is to remedy the harm and to fix the violation, that is a very efficient way of doing that, getting the Attorney General to write a letter without having to expend the resources of opening up an entire investigation. The right to cure gives them a tool with minimal resources that can be very effective.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Winkler. Are there any other questions? If not, I'll proceed with my questions. I don't see any hands raised. So Ms. Livin, I just want to start by following up on Representative Winkler's question. So let's say now, without having the bill in effect, does an individual have any recourse if their data has been used in an inappropriate manner?
Yeah, today, a company's privacy policy communicates to consumers and represents how companies collect data, what they collect, for what purpose, how they use it, with whom they share it, and what the consumer's rights may be that they are willing to offer. If a company uses data in a way that contradicts the representations that they've made in their privacy policy, state Attorney General under the unfair and deceptive Acts and Practices Act, the Consumer Protection Act, could bring an action against a company for misrepresenting its privacy practices as they've been disclosed to consumers, bring a consumer protection action against a company for that, as could the Federal Trade Commission do the same, bring an action against a company for violating the promises made in its privacy policy. The Federal Trade Commission takes a similar approach. They don't open an investigation, formal investigation into every complaint they receive about a potential violation, but they do a lot of investigating and working with companies to help bring them into compliance if they receive information that a company is out of compliance. If it looks like there's something nefarious, if a company is being careless or worse, then that's a different story, and they would bring an investigation and bring the full weight of the agency behind an investigation.
Thank you. I want to go back. You just talked about the right to cure, and that was one thing that the Attorney General's office had testified about, was that in some ways that could become burdensome for them with their notification, and it may inhibit enforcement. Can you speak to that? So again, you had said that you would, I guess, endorse the legislation as it's written, but of course respect the right to object with any changes that are made. And being that that is one change that was recommended, can you comment on that?
Sure. I think if the objective is to protect consumers, the greatest number of consumers, I think that having the right to cure is the most efficient and fair way to do that. It's efficient because the Attorney General can put a company on notice of a violation without opening up a formal investigation and expending resources. Again, it's the same approach the FTC takes. And because they can trigger that right to cure with a simple letter, which can be sent to numerous companies at once, this approach has the potential to affect a large number of consumers and provide meaningful protections to them in a very short period of time. Consumers have 30 days to come into compliance. If a company has not paid attention to privacy and has not put in place an internal compliance program, that will be very apparent within 30 days. There is no way a company will be able to get its house in order. These privacy compliance programs take months and months to put in place. So that will be very apparent. And if they fail to come into compliance, the Attorney General can bring an enforcement action and seek these steep penalties that the bill provides. It really, as the California Attorney General testified before Congress last fall, it really acts as a force multiplier for the Attorney General, and it gives them a tool that they don't have when they are forced to rely on the rather cumbersome enforcement infrastructure that they'd have to galvanize into action otherwise.
Thank you. Another thing, you testified about this bill taking a balanced approach. Could you give us some examples, I guess, of an unbalanced approach?
Yes, I think a bill like the California bill is an unbalanced approach. The California bill is very prescriptive, and it seeks to protect consumers through a sort of a web of notices and links on companies' websites, and it provides overbroad definitions of certain things like personal data that don't allow for the beneficial uses of information that are essential to enabling consumers to get what they want in the marketplace while being protected. And just to give you one example of that, I'll give an example of what was corrected in the CPRA, the subsequent California law that's now going into effect. the definition of personal data in the initial version of the CCPA is extremely broad and captures virtually, it almost captures virtually everything. If it's any data that can be associated with a specific individual, that really could be anything. And it defined de-identified data as the inverse of that. Any data that doesn't meet this definition failed to provide sufficient clarity. The subsequent iteration of that bill, the CPRA, defined that more clearly and in a way that now allows companies to confidently use de-identified information in a way that they know will be in compliance with the law and will also will also allow them to develop new services and do the kind of internal operations that they would like to do without triggering compliance with the law.
Thank you. And I guess, one of the things that's critical is definitions, right? And so you just kind of started going over the definitions. The other thing, we talk about, I guess, in terms of what entities are covered by this, and the Attorney General had testified to the fact that, this bill provides carve-outs for entities rather than information. Is it possible, I guess, can you comment on that, that issue, and how we would, recommendations on if it's possible to just carve out, again, the data or the information rather than giving an exemption to entities who utilize that information? Because I think then the unintended consequence would be other information that they collect that may not be, that we wanted to carve out, they may be exempt from.
Yes, so I'm not entirely sure whether the issue there was that the bill carves out, for instance, certain entities that are regulated by HIPAA, the health privacy law, or the financial services privacy law. If that's the case, that is the approach the bill takes. It carves out certain entities that are regulated under other laws that cover sector-specific, that are sector-specific privacy laws. I think that's the right approach because the laws that govern, for instance, healthcare providers and covered entities under the federal health privacy law, that health privacy law that is that's the subject of the carve out regulates the entity as well as the information. And if the information goes to a different entity, the regulation focuses on the entity, not always the information in those instances. I don't know if that's very clear because I wasn't entirely clear what the concern was about following the data, not regulating the entities and not the data. I think generally, putting aside the carve-outs for sector-specific types of information, generally, I think it is best to regulate the data and not different entities, depending on what kind of entity it is.
Okay.
Yeah, I think, and you do that. You focus on sensitive data and treat that differently than non-sensitive data, and I think that's the right approach.
Okay, thank you. Another thing is interoperability. I think you've mentioned that, and we don't want to necessarily a patchwork of different state regulations with differing definitions. I think one thing we've seen is just what a business is called is different from state to state, right? Covered entity, business, controller, they all essentially mean the same thing. But how do we ensure that, as it's likely that other states will come up with legislation that our definitions and the bill stays, we're looking now with the places that have passed to try to, as best as possible, align our definitions. But of course, we can't see into the future. So is there a mechanism that we can put in place to help ensure interoperability going forward?
Well, I think the approach you take, which is modeled obviously after Virginia, which in turn was modeled after, in large part, the European regulation, is a very good approach. It is the European regulation touched so many US businesses that target consumers in the EU that it is a something that people are familiar with, and I think is flexible enough to be adapted as laws that might be take a slightly different approach come up. But I think the controller processor definitions are the most useful and flexible.
And then can you give us examples of controller, processor, and third party, what they may be? I think it's, for me, I like having, well, I'm visual, not that I'll necessarily see that, but I see having specific examples makes it more clear.
Yeah, sure. A controller is an entity that, and by definition, decides the purpose and means of processing. That means that it controls the data and decides what it wants to do with the data and how that should be accomplished. So if, for instance, you have a company that wants to market to its consumers and it wants to target them based on their demographic profiles, that company is acting as a controller and making that determination of what to do with that data and how to get that done. It then would go to a processor that is in the business of providing services, marketing services. It's a service provider or a vendor. And that processor would say, yes, this is the service we offer, is to take data and create these demographic profiles so you can target consumers based on that. In that case, that entity would be a processor. Now, if that entity were able to use that data for other purposes, and I'm borrowing a little bit of a just kind of idea from the California law here, which defines third parties in the same way, then that entity is no longer a processor, but a third party. So they're not just following the controller's instructions anymore. They're using that data for their own purposes as well. And if they do that, then they fall out of that definition of a processor. If the processor's obligations are defined by contract with the controller, and if they deviate from that and use data for other purposes, then they're a third party.
Okay. Now, so in California, I believe they define, who comes under the auspices of their bill by 50,000, right? Uses or controls 50,000 pieces of data in a year, whereas in Virginia, the proposed COPRA and our bill are 100,000. Can you give an example of what it would take and specifically what it would mean to, as it's defined in here, how you would reach that piece of, controlling the information, 100,000 consumers?
Yes, so I mean, that is, there are a number of ways you could reach that mark. Think of a small coffee shop that would have to have 100,000 unique Connecticut consumers in a year to trigger that threshold. Unique, it would have to be unique customers, right? So you have return customers would not trigger the 100,000 threshold. For companies that do business online, it's a little bit trickier because if an IP address is personal data, because it can be linked to a specific person or device, namely the computer from which the person accesses a website, a unique IP address, unique IP addresses could add up quickly. So, 275 hits on a website a day from unique Connecticut consumers could, over time, each day, have to be new people each day, could trigger that that threshold. I think it would take a while to reach that. And I think, the bill is wisely drafted in doubling the number in the original California law. So I think that this should protect small businesses and allow them to grow, give them a chance to grow before triggering the law.
And so let's use that small coffee shop as an example. And let's say that they are doing their advertising on Facebook, right? In that example, I would assume they're not a controller because they don't, they're just, whether they're doing a sponsored post or some other ad to try to drive people directly to their business versus, I guess they wouldn't be controlling the information unless the person clicked from their ad and went to their website. Is that?
Well, they're a controller just by virtue. So in order to advertise on Facebook, they would probably put a Facebook pixel on their website, which collects information about visitors and then shows those visitors ads when they go to their Facebook page for that coffee shop. And so by virtue of doing that, putting the Facebook pixel on the coffee shop website, allowing that data to be collected and shared with Facebook for retargeting, they would be a controller.
Okay.
But if they're not getting 100,000 unique hits a year, they're not going to trigger the law until they get up to that point.
And so they would have to be unique. So if I go once a month or whatever, I'm not 12 and I'm just the one.
Right. It's not, yeah, exactly. Same person going over and over again should not trigger this. That's not how I read it.
Okay, great. So I guess that, again, we're trying to strike the balance between protecting consumers, right, and not inadvertently overburdening small businesses. And I think that that's what we want to make sure, that we're not dragging in a small coffee shop that is now going to have a high cost of compliance inadvertently.
Right. And doing the data protection assessments would be a huge burden for them, for sure.
Correct. And a data privacy officer would be unnecessary, I think, for that size. So, okay. Carve out, trying to look through some of the others. Trying to think of other questions that I may have missed. I think one question is, I understand that Virginia is, they're going to have a working group to look at their bill and potentially make changes. And we do look at the same as pushing it out, the date this would go into effect till January 1 of 2023. Would you recommend we take a similar approach in developing a working group? And if so, who would you have recommendations for who should consist that working group?
Well, I think if you do a working group, I think it should obviously be balanced. And I look again to, I mentioned the FTC's approach earlier and the approach it took to developing its privacy framework. And it had representatives from industry and from consumer advocates and from government and academics as well as part of that process to really get a 360 view of the issues and how it would impact the various constituents. So I think that would be the approach to take.
And then I think I'll ask the same question I had, because we had passed legislation. Well, the House passed, it hasn't gone before the Senate yet, to provide a tax credit for data processing facilities in the state. How would they be encompassed by this bill? And again, we don't want to send one signal that we're open to you and another that we're we want to overburden you. So just making sure that we're striking that correct balance.
Right. So I think, and it's hard to say, as you can see, the determination about whether a company is a controller or processor is really fact specific, and it's really going to depend on what is going on and what the activities they're engaging in are. And you can be and I assume this is the same as under the European statute or the European law, you can be a controller for some purposes and a processor for others. So you can slip into that new role with respect to the various activities that you're engaging in. So let's assume that those databases, that those data centers are processors, and that's all they're doing. Their obligations would be governed in large part by the agreements in place with the controllers who do business with them. And so that would be separate from the statute, would just require them to adhere to the agreements they enter into, and a few other things to assist the controllers in responding to requests for access to data and so forth. Again, these are things that if they're large companies that are going to establish data centers in Connecticut, they're going to be familiar with these kinds of obligations already, as under the GDPR, they've already got to do that. So the one thing I would say is that there is a requirement in the bill that controllers exercise reasonable oversight to monitor the compliance of processors with certain obligations with respect to the use of the processing of pseudonymous data. That is something that is different. I mean, it's definitely puts more restriction on data processing than we've seen in other bills. And I don't know how that would work out, but that is something that processors might not have to face in other jurisdictions that they would have to face there.
Thank you. And then I do have another question. I was still trying to fully comprehend the difference between controller, processor, third party, and coming back. I think I have it a little bit, but I'm going to use myself as an example again. So if in my business, one service is, people send us data about their clients and we send them back a report. So as long as I'm not doing anything else with that data, I'm just sending it back to them as a report, I am a processor.
Correct.
Is that correct? Now, in some instances, they may send someone to my website, send their client directly to my website to enter the information to get that report, in which case they may get, as we talked about, a pixel, so that we could use that, advertise to them or other. So in that case, I would be a third party. Is that, or is that unclear?
That's unclear. I mean, it depends on that relationship. If this is somebody, you have no idea, if your website just collects data through the Facebook pixel to share with Facebook for advertising, whoever goes on the website, could be me, even if I don't have a relationship with any of your clients or whomever, you're acting as a controller in that case, and maybe Facebook is too. It just really depends on how Facebook is able to use that data, what their restrictions are, if any, on the use of that secondary use of that data, or if they're only using it to advertise your services to Facebook users.
Okay, thank you. And Representative Winkler, I see, is your hand up for another question, or that's from okay. All right, and I think that it is all that I have. I'm going to see if anyone else has a question. I don't see any other hands raised. So with that, thank you very much for your time and for your testimony today.
Thank you very much.
Okay. All right, Mr. Clerk, next is Jody Fenelon.
So Jody Fenelon is not in yet. I don't see her. So we can just move to Sharon Jocelyn.
Okay, that would be great.
She's coming in now.
Good afternoon. Sharon Jocelyn. Well, let me start my video. It just appeared. Thank you very much. Hi, and good afternoon.
Good afternoon, Ms. Jocelyn. Thank you for coming to testify.
Well, I thank you for having me, and I really want to thank the entire committee for listening to our information today about changing the statutes of the Senate Bill 895 to allow changes in pharmacy statutes. I work as the clinical director under Dr. Frederick Altice, who will be speaking next. I'm an APRN and a family nurse practitioner, and I also treat substance abuse addiction, and I treat general medical problems and mothers and babies. We provide a medical service that reaches out into the inner cities, generally mostly in New Haven. And we work a lot with the New Haven Department of Health, Department of Emergency Services to try to help bring together all our services to generally help the persons suffering from substance use disorder. My department is in the Department of Infectious Diseases and HIV and AIDS and hepatitis C, and I treat quite a bit of that. So we've seen it on firsthand basis, and we are in the community out on the roads, and we also have a office site as well. And we really are trying to assist our clients with access to the sterile syringe supplies that we know has demonstrated for years in the HIV and hepatitis C literature to reduce transmission of infectious diseases, which is on the rise in Connecticut, as well as the opioid addiction, as well as fentanyl use, and as well as problems associated with those in treatment. But we have noticed that sterile syringes decrease because people do not share the syringe or the device or the needle. So we're in the midst of this volatile opioid epidemic and a large number of people who are injecting drugs in our state or snorting, as we have seen increasing recently, especially with cocaine laced with fentanyl. Clients can only obtain these syringes from our syringe service program, which is a part, which there's about 10 in the state of Connecticut, which we are so grateful for having because it allows us to distribute syringe services under the Department of Public Health and Addiction Services and HIV prevention specifically program. And during COVID, additional stressors have been put on our clients for people who inject drugs, and they need more access to services than less because COVID has obviously limited a lot of the accessibility. They also can be purchased. The other problem, they can be purchased from other suppliers that are not in the legitimate business of treating drug addiction, such as small bodegas and small stores that are selling them under the counter for very high prices. So our harm reduction dispensing machines are managed by our qualified syringe programs and with knowledgeable and licensed care providers and case managers training to interact we do every day with our persons of substance use disorders. The vending machine is a unique device that has information for how they reach us, our contact numbers for other substance abuse treatment programs, and access 24/7, safe, locked, secured, and they also link them to mental health services. And it's
Ms. Johnson, just a heads up, we're at the 3-minute marker.
Okay, so in short, it reduces infections. It links people to community services. It's clean, it's safe, it's locked. I pick them up and the disposals and I stock it. We have a disposable bin that is locked and usually adhering to this. And it also can be used by insulin users who have anyone that uses or hormone users who need that. We manage by, it's open 24/7. We meet clients where they are. We don't monitor them by that. We have a secret, they have a code that we use with them, with the Department of Public Health. So we know who is using and how they can contact us. 10 syringes a day is very limiting for someone, especially if they're in a group of other people. Then we encourage people, do not use alone because of the need for someone to be able to administer Narcan if there's fentanyl, and there's fentanyl in everything.
Thank you, madam. Let's see if there's any questions from members.
Thank you.
Any questions?
I don't see any hands raised. Anybody? So I'll ask you a quick question if you don't mind. Where are your vending machines? Where would they be located? Do you have a physical location?
We're working on that with the city of New Haven, and the city and the lawyers, that we're trying to figure out where they would be that are safe, protected from weather, protected from and also able for us to access them. So we're working with Dr. Dalal and the Department of Public Health in the city of New Haven to determine those sites right now. We don't have the sites firm because we're waiting for legislation to change from your committee.
So
on this bill,
you're not dispensing any medication per se, except possibly Narcan, but just the needles that the addict, the harm reduction needles that the addict could use. Is that true?
right? And with a needle, if you're gonna, just like when you go to the hospital and you get a shot, you need alcohol, Band-Aids, antibiotic cream, and we can put in health hygiene products like hand sanitation, face masks for COVID. You can load it just like they changed the water in the candy machines with whatever's occurring at that time to help us reach out to our clients.
So the law presently as written before us, the bill before us, would it allow you to accomplish or achieve the goal that you're looking for?
I believe so, yes. Because even when I talk to pharmacists, they are limited. They say, I'm sorry, I can only, even if I write a prescription for 20, they can only do 10 unless it's for certain medical reasons. So this, I think, would be terrific. Thank you so much for listening.
Thank you. Thank you, madam. Are there any questions from any members? Senator Maroney had to go to veterans, so I'm temporarily filling in. So, Mr. Clerk, thank you for your testimony, madam.
Thank you.
So up next is Frederick Altis. He's in now.
Yeah, I'm trying to get my video. Excuse me. Can you hear me now?
Yes, sir. Please proceed.
So good morning, distinguished members of the General Law Committee. I'd like to thank you for the opportunity to express my strong support for SB 895, an act concerning changes to various pharmacy statutes. I'm Rick Altis. I'm a professor of medicine, epidemiology, and public health at Yale University. I'm also a treating physician certified in both infectious diseases and addiction medicine. And I direct several programs that are related to this proposal, including the community healthcare van about which Ms. Jocelyn just spoke about, in our syringe services program. I'm here specifically to speak in support of Section 3C, which would allow increased access for harm reduction services, including these harm reduction dispensing units. One of the things that has been clear is that harm reduction services have evolved greatly over the last several decades. I was involved at its inception back in the 1980s and introduced the community healthcare van to link health and prevention to the harm reduction program in 1993. And in 2017, we have also been in charge of running the syringe services program for the city of New Haven. The program has evolved and has become a nationally recognized model for integrating both harm reduction and treatment services. But one of the things that has certainly emerged is that the COVID pandemic has resulted in a need for innovation and transformation in the way that treatment and prevention services are provided. And aligned with the governor's orders to sort of engage in physical distancing and to reduce personal contact with others in the community, we have modified and adapted our services by working with a number of community partners to sort of increase access. This access is sort of inconsistent with the physical distancing sort of programs that are recommended right now. And I think that we cannot think that even though that we've had this market decrease in the downward trends in the COVID pandemic, that we can become complacent, because there are sort of new strains that are emerging that are increasingly transmissible, and some of which may not respond as well to the vaccine. I also think it's important to recognize that people with opioid use disorder are at a 10-fold increased risk for acquiring COVID relative to those without it, which means that we have a double duty to sort of enact these services for these individuals. These individuals who are in the community, we've sort of noticed that during the COVID epidemic, there's an increase of 17% in opioid-related overdoses, with new outbreaks of HIV and hepatitis C, especially where people do not have access to these services. Part of the sort of response to the COVID epidemic is many harm reduction programs around the country have shut down all of their in-person visits. We have not, but this has unintended consequences. And we have worked with the Harm Reduction Coalition led by Mahal Dalal at the City of New Haven's mayor's office, and to coordinate some of these activities. And this is aligned with his report that he submitted to your committee earlier. Our goal is to make these dispensing units available at least initially in 3 diverse neighborhoods in New Haven. The exact area has not been identified, but we use heat mapping to identify where there are the biggest problems. And there are certain neighborhoods where that's clear. It would make it available during non-business hours. They will address both individual and public health by reducing in-person contact. And one of the things that—
Excuse me, Mr. Altice, just a heads up, we're at the 3-minute marker.
Great, thank you. I'll take 30 seconds more if you will allow me. I will say that these machines have been successfully deployed in many parts of Europe. I've traveled to these sites. In the last several years, they've also been deployed in Nevada and Puerto Rico, and the District of Columbia is calling for proposals to implement them there. They're designed and constructed to withstand most security concerns. In other settings, they've been used for controlled substances. That's not what our plan is, and other medications, so they're quite hardy. We would adapt them for harm reduction, which would be an innovation. We will be able to control who has access to that through a card key or a key punch-in the same way that we heard about these dispensing machines in nursing homes. But we would clarify 2 points that were raised by Senator Witkos, which I think are important. Each machine would be equipped with a secure Sharps container, either attached to it or nearby, to reduce the risk to others. And then my other understanding is that the previously imposed limits on syringe services program was revised in 2017, and no limits remain, except for with the exception of pharmacies. And so that would be something to think about as you're sort of moving forward to relook at the languages. They're not intended also to eliminate interpersonal communication, but really to provide an additional point of access, because all of these people are engaged with our program irrespective of this. So it does allow us to remain in communication with them, do naloxone overdose training. And they have really been found, at least with a decade of experience in Europe, to be safe, securely constructed, and really provide a valuable asset to the communities they serve. I'd like to thank you for the opportunity to share our perspectives on this, and look forward to any questions that you may have.
Thank you, Doctor. Senator Maroney, you want to grab the reins?
Oh, sure, Representative Tigliano. You were doing a great job, so thank you.
If you were still busy, I'd be happy to continue.
Thank you. Are there any questions for Professor Altice? If not, I do have a question. I guess besides for your background, I'm assuming that well, I don't know if that's Sterling Library or Hogwarts or something else.
I have 7-year-old twins, so they think it's Hogwarts, but it is the Sterling Library.
Okay. Oh, okay. So that was the easy question. The second question is back to you had just mentioned that I guess in 2017 the legislation had been revised, so there's no longer a limit on.
There is a limit for pharmacies, but in terms of sort of a licensed syringe program, that restriction has been removed, as I understand.
Okay.
Yeah.
Great. So thank you. And I guess we'll want to look at the clarification and if it's been removed, if it would make sense for pharmacies, why I'll have to do research on my own end to understand why we still have it in place for pharmacies, but we've reduced it in other places. But it would make sense, as a testimony has said, that they'll often use more than 10.
Yeah.
It's possible to use more than 10 syringes in a day.
Yeah, so they certainly, might. And one of the things that's sort of really interesting about these machines is you can put any kind of limits in terms of like which clients that might get, let's say, option A, B, or C in your quote unquote in your candy machine.
Right.
And you can also limit the number of times that they access it. So there are all of these built-in things that can change and emerge if you identify that things are evolving. And so there is the ability to be really maximally flexible with this.
And that's great. And so there are a lot of controls because they are using an identification number, which I'm assuming, I don't know if it's tied to a card or or they punch in a code when they go there. However it is, you do know which individual is accessing the machine. So that is.
As you heard from the testimony earlier around nursing homes, it would be the same thing where you would, like, a specific nurse would be linked to a specific code in order to pull out a certain medication. The same sorts of controls would apply here, so that a specific client would be linked to pulling out items A, D, and E, for example.
Okay, great. Now, do you have any, just because you've mentioned that example of the automated prescription machines that that are currently utilized in hospitals, we're looking to extend that to nursing homes. Do you have any experience with those background you could provide, other than it's a similar technology to what these vending machines would utilize?
Yeah, I would say the technology is slightly elevated, maybe perhaps on steroids relative to what we're talking about.
Right.
But I haven't worked in the sort of the nursing home environment. But what I will say is if you sort of apply even within a hospital, like to an emergency department or any of these sort of satellite sites, it increases the accessibility to gain access to real-time medications. And those same sort of controls that are happening centrally allow you to monitor that so that those kinds of protections are there. So I'm not an expert on that particular part of it, but it works the same sort of way. And even 10 or 15 years ago, moving these Pyxis to the wards as opposed to shipping the medications up through a tube system allowed for us to provide services in real time and much, much more safely because things just didn't sit around on each and every floor.
Right. So there are the controls where it actually, some people may assume that it would decrease the safety, but it sounds like that there's more accountability and it increases safety by less potential for error and less hands that have to touch something before it gets to the actual patient.
And I think the safety codes, as I mentioned, the Pyxis has a much more deeply regulated system because they're oftentimes pulling out controlled substances. And so it's a little bit different, but we have those same sorts of controls by, unique client person that's enrolled in our program. So these are people who get enrolled. We know who they are. We know how to communicate with them. And then when they queue in, we can also look at their patterns of use, et cetera.
Okay. Great. Thank you very much, Professor Altice. Are there any other questions? If not, thank you very much for your time, taking the time to testify before us today.
Pleasure. Thank you so much for the opportunity, and thank you for the support and all the work that you're doing on this really important bill.
Thank you. Mr. Clerk, is it Stephanie Luan or did Jody Fenelon ever?
Jody hasn't appeared yet, so Stephanie Luan is next.
Great.
Good afternoon. Is everyone able to hear me okay?
Yes, we can hear you, Dr. Luan. Please proceed.
Wonderful. Thank you so much. So my name is Steph Luan. I am a licensed pharmacist practicing in the ambulatory care clinic setting within a large health system in the state of Connecticut, and am the current legislative chair of the Connecticut Society of Health System Pharmacists. Thank you so much for allowing me the opportunity to speak today on behalf of myself and the Connecticut Society of Health System Pharmacists in strong support of Raise Bill 895 and act concerning changes to various pharmacy statutes. You may have already seen from the positive testimony shared from colleagues and advocates across the state that they have the same request. Pharmacists are one of the most highly trained and underutilized healthcare professionals. I graduated with a Doctor of Pharmacy degree and then completed 2 years of specialized residency training. I'm board certified in pharmacotherapy as well as ambulatory care pharmacy. This bill, as proposed, doesn't change pharmacists' scope of practice at all. It just eliminates an outdated administrative burden for pharmacists, physicians, nurse practitioners engaging in these agreements that was created prior to the availability of the shared electronic medical records. It also provides clarification that a written protocol within a CDTM agreement may include guideline-directed management. So the first update really modifies the requirement that a pharmacist shall report out at least every 30 days to the physician or APRN regarding the patient's therapy management. And here are some key reasons why this is important. So the pharmacist might not encounter every patient every 30 days. For example, if a patient's engaged in CDTM for tobacco cessation and they've been tobacco-free for 3 months and they want to extend their visit out to 6 weeks because they want to remain accountable and have an accountability buddy in that pharmacist who can give them professional advice, but at the same time, they want a little bit more freedom and a little fewer touch bases with the pharmacist. Currently, the way the statute is written, we're required to report out to the physician or APRN every 30 days. Conservatively, we may also have to reach out to that patient and check in on them and say, hey, how is everything going? I know we're not meeting for another 2 weeks, but is there anything I can do for you? Which really does is really not wanted by our patients. They receive enough medical calls related to their care, reminding them to pick up their medications, reminding them to do all of these other things, that it's creating undue burden. It's also cluttering the patient's medical record when we're documenting these outreach attempts and routing them to a physician who may really only want to focus on things that they actually need to address. So there are really a plethora of additional examples shared within the written testimony for this bill, so I'm happy to share more if asked. But when both parties are engaged in this CDTM agreement, they do have access, for the most part, to the same electronic medical record. So it really makes sense that we're able to meet that communication requirement by a pharmacist documenting in the EMR. And any medication changes are made within the shared medical record, so they're already available to the clinicians. The second piece that I wanted to point out is the clarification that a written protocol within a CDTM agreement can include guideline-directed management. So really what we're looking to clarify here is you could conservatively interpret. There's no really good definition of a protocol by CMS. We've scoured the literature, and you could interpret that a protocol is an if-then statement. And really, that doesn't lend to good medical care. There's no way that you're going to be able to create a protocol that fits every patient need. So what we generally do in practice and what our providers and clinicians do are follow national guidelines. They select a guideline, agree with it, like the ADA guidelines for diabetes, for example, and kind of go from there. So I grew up and went to pharmacy school outside of the state, but I decided to practice in Connecticut because of my experiences as a pharmacy resident and the strength of the relationships and interest and collaboration with pharmacists, physicians, APPs, and other multidisciplinary members of the health.
Just a heads up, you're at the
Yes.
3-minute marker.
Perfect. I will wrap up. Thank you.
Thank you.
So as the value of the pharmacist within the interdisciplinary care team in both inpatient and ambulatory settings led to the creation of new integrated pharmacist roles, we've really come to identify some of these barriers to expanding our care. And we're hitting these administrative burdens when we could potentially be seeing more patients. So for that reason, I'm happy to answer any questions, and I hope that you'll support this bill.
Great, thank you very much. Let me see if there are any questions from the other members of the committee. I will ask some, but I'm just gonna look and see. Okay, I don't see any other hands raised, so I'm gonna go ahead and ask my questions. If anyone else has questions, just raise your hand and I'll recognize them. Can you just give me an example of what guideline-directed management would be, like a specific case? Like,
Yeah. Sure. So I see patients oftentimes who are referred with elevated A1Cs or average blood sugars. So say a patient is referred to me with an average blood sugar of 14. The American Diabetes Association guideline specifically states that for A1Cs greater than 9, you should start insulin. It does have considerations, though, that if your patient refuses to start insulin because they say, I'm not using needles, then you can consider these other therapies, but eventually titrate up appropriately. So it kind of gives a guidance and algorithm and includes patient-specific factors, patient-specific considerations. It lists all of the lab values that you may need to order in certain circumstances. Like, for example, if you're starting a new medication and you want to check someone's renal function or kidney function 2 weeks after starting it to make sure that there were no issues. It also gives you goals of therapy based on different patient populations. So for example, an A1C target goal or an average blood sugar goal for an 85-year-old patient is likely going to be a lot looser than a young patient, because in diabetes, we think about we're preventing comorbidities and mortality in the end. We're preventing those macrovascular and microvascular complications, amputations, blindness, things like that. So we have a longer lifespan to do that in a younger person than in an older person. And so when I had met with legal counsel at our institution previously, they had provided guidance that it was kind of a gray area where a protocol might have to be black and white and say, okay, if the A1C comes back at this, start this medication. If this, do this, rather than going based on nationally accepted guidelines that are updated frequently. And really you can set stipulations in that collaborative practice agreement for which guidelines you should follow. Was that helpful to answer the question?
Yes, and actually that kind of leads into my next question. So, I've heard that these changes will help you, help pharmacists to practice more within the scope of their training, that they're not able to utilize the full scope of their training. So it sounds like, in this case, if it was just purely an if-then, you're not able to take other factors into consideration that you've also been trained for. Is that a safe assumption? And then could you also, and if I'm incorrect on that, which I may be, but can you talk about how this will allow pharmacists to practice more within the full scope of their training, and then speak to the fact that I have heard that it has been difficult and sometimes to recruit pharmacists because we do limit them. So examples of how the current system limits pharmacists.
Sure. So I don't think that this is going to allow pharmacists to practice more at a higher level. The only way I can see this doing that is because of the reduced administrative burden in terms of not having to contact the patient every 30 days and report out. We'll naturally be able to see more patients because we'll be wasting less time contacting patients who don't necessarily need us the most. The guideline versus protocol really just means like we could spend hours and hours and days creating an intricate algorithm with the provider for each patient saying, okay, if this happens, do this. If this happens, do this. If their A1C comes back and it's 5.7, discontinue this. If their A1C comes back and it's 6.3, do this. But it might not be something that the patient's actually interested in. And this is something that organizations across the state are already doing. They're already practicing in accordance to guidelines. It's just we needed this kind of clarification. And in my conversations with the Department of Consumer Protection leadership, they said that the intent was not for it to be a black and white sort of thing. So really, it's not changing the pharmacist scope of practice because it's still within the constraints of that guideline. So it's not like they could just decide, okay, well, I heard about this therapy and it's really great, and because of XYZ and all of these studies, I'm going to recommend it. It still has to be something that makes sense within the scope of a guideline, if that makes sense.
Yeah, no, that's perfect. So I guess where it helps is in reducing time, right? And no longer having that 30-day that you always have to report. And then as far as being able to go within the scope of the guideline, it would be burdensome to come up with a complete protocol for every situation, but, trusting that since you are following and clarifying more, since it seems that was the intent, but it could have been interpreted as, by the strict letter of the law that you couldn't just use the guidelines, you would have to use a rigid protocol. Is that
Yes, and one more example that might be a little better that I can share is recently we have been trying to transition from a protocol, like strict protocol based warfarin management protocol. So a lot of times it's an if-then statement. It says if the patient's INR or their measure of how thin their blood is comes back within a certain range, you increase the dose by this much percent, or you decrease the dose by this much percent. And if, for example, the patient ate more vitamin K in their diet, it might not be because their dose, like their INR might be off because their dose is not necessarily wrong, but because of their diet that week, because it doesn't follow within that protocol, we have to reach out to their referring provider every single time. So we've recently transitioned that, or in the process of transitioning that, to a collaborative practice agreement or CDTM agreement, because we can include things like vitamin K can potentially decrease your INR. This can potentially do this, and like what considerations you should take into account. And so we had that guideline that we developed go through one of our heart and vascular leadership committees and a bunch of other committees to see if the providers who were going to sign on to the agreement agreed with that plan. And so that's kind of another example. And I apologize, I forgot to answer the question about recruiting pharmacists into the state. I think that's going to be something that we'll have to focus on in the future. I think when we first came to you and to chair committee person, Senator D'Agostino or representative, we had hoped to also expand this more to a population health-based agreement, but after conversations with the Department of Consumer Protection, they felt like that would not be something to do without fleshing it out a lot more. So that's future.
Okay, great, thank you. So this is a very limited change, right? And it's more on the intent, eliminating an outdated regulation and then bringing the statute in line with more of the intent of the initial statute. It's just is interpreted overly narrowly, it seems like. Okay.
That's my understanding. Thank you.
Great, thank you. Are there any other questions? Seeing none, thank you very much for taking the time to come testify before us today.
Thank you for having me.
Okay, Mr. Clerk, I believe next is Brian Murray.
So Jody Fenlon just came in. So
okay, great. So Miss Fenlon.
Okay, can you hear me?
Yes, we can hear you.
Great, thank you very much. And I'm sorry about my availability issue. And thank you for this opportunity. Co-chair Senator James Maroney and Representative Michael D'Agostino, Ranking Senior Senator Kevin Whitcoast, and Representative David Rutigliano, members of the General Law Committee. My name is Jody Fenelon. I'm a pharmacist and the VP of Compliance for Partners Pharmacy, and we have a location in Connecticut. And I want to thank you for the opportunity to express my support for Raised Bill 895. As a Connecticut licensed pharmacist practicing in long-term care, I believe the ability to implement on-site automated technology for medication availability in long-term care facilities will be of significant benefit in the care of the residents. Specifically, the addition of the definition of automated prescription dispensing machine will clearly delineate the type of technologies that may be utilized in facilities, providing clarity on the difference in functionality of automated devices that are available. Also, the inclusion of Section 2, Parts A and B will expedite the opportunity to implement use of the automated prescription dispensing machines in long-term care facilities in a safe and consistent manner while regulations are promulgated. There are numerous benefits to automated prescription dispensing machines in long-term care facilities. I'd like to share a few of those with the committee. Safety and accuracy. This is key. The technology our company uses has a proven record of safety and accuracy. It has been used since 2002 and is currently operational in 9 states, soon to be 10 as of March 1st, and in over 130 long-term care facilities in those states. The accuracy rate is noted to be very high at 99.9998% documented. All medication orders are reviewed by a pharmacist prior to packaging to ensure the appropriate clinical review is completed, and all medications placed in the system are checked by a pharmacist prior to dispensing from the pharmacy. There is a barcode verification process that occurs every time medications are loaded in the machine and each time the machine is opened to confirm the accuracy of the medication placement. Another benefit is medication availability. With medications available on site, including controlled substances, medications are available to promptly care for new admissions, new medication orders, or change in patient condition. This can significantly impact the ability for the facility to manage the clinical situations on site. Another benefit during this, which has always existed but has been enhanced with COVID challenges, is infection control. The packaging of the medications on site in patient-specific, individually labeled envelopes minimizes the handling of medication cards or vials that can become soiled with repeated handling. The individual envelopes are disposed in PHI secured trash after administration to the patients. Another benefit is cost control. Medications packaged through the automated prescription dispensing machine reduces cost as only doses packaged for administration are charged for, different from the typical dispensing of a 30-day supply to a patient that may or may not be fully utilized. This benefits all payers of pharmacy costs in long-term care, which includes Medicaid, Medicare D, and the nursing facility themselves. The last benefit I'd like to mention is diversion prevention. And automated prescription dispensing machines provide controlled substance management by only packaging the medications when ready to administer, minimizing the amount of controlled substances in circulation in the facility. I strongly support the approval of Raise Bill 895 to advance the provision of pharmaceutical care in long-term care facilities via use of the automated prescription dispensing machines. And I thank you for the opportunity to speak to this, and we'll certainly answer any questions that you may have.
Thank you very much. Senator Kissel?
Yeah, thank you, Mr. Chairman. I just have a quick question. I have no idea what PHI controlled trash means. What is that?
Just appropriate trash where any document or item that has protected health information on it would be destroyed versus just the regular trash can in the residence room, let's say, that they would be putting it in some sort of shred box or some sort of trash that is specifically for PHI.
So that means particular health information?
Protected health information, like the patient name, room number, and so on, anything that would be that all of us want protected with our health information. So these items are labeled with the resident name and their room number and so on. So we would want that destroyed, not just in the regular trash in a room where someone could see it, or out in the hallway. It would just be in a secured type trash, which the nursing facilities all have already.
Now, like if these machines are out, like the gentleman, the doctor from Yale, they want to have these out in New Haven. Like, how are they going to do that?
So, Senator Kissel, this is we're looking at two different, the machines that are, and I apologize for interjecting, Ms. Fenelon, but there are two parts of the bill. So one is that will be out in New Haven would be for dispensing the hypodermic needles, whereas this is, which would only be allowed in long-term care. These are for dispensing the medications, automated dispensing that is currently available in hospitals, but we're looking to expand that to long-term care facilities.
I appreciate that, Senator Maroney, and I actually had a meeting with the advocates for this particular bill, and I probably should have recalled that, but after several hours, it's apples and oranges. So I apologize for that question, but now I get it.
Okay. No, it's been a long hearing, and you've been on, from what I can see, almost the whole thing, so I understand the confusion.
No two ways about it. The whole thing since 9.
Yeah, yeah. Other questions for me? I'm glad that I couldn't answer what Yale was doing, so I'm glad that was able to be answered.
So thank you very much. I do not see any further questions, but you did clarify a question I was going to ask for you. Was it how many other states is this being utilized? So 9 and soon to be 10, as well as that
Yes.
there are 130 facilities already utilizing this technology. So thank you very much for taking the time to come testify before us.
Yes, and thank you for your understanding and shuffling around the schedule to accommodate me. I greatly appreciate that.
Oh, no, like I said, we appreciate you taking the time. So thank you very much and have a
All
great
right.
day.
Thank you.
Okay, Mr. Clerk, next up is Brian Murray, I believe.
Yes, and I'm promoting him now.
Okay.
He's in now. He just needs to unmute.
Okay.
Here he is.
Okay, I'm unmuted.
Yes, you're unmuted. Please proceed, Mr. Murray.
Sure, thank you. I don't see video of myself, so perhaps my camera's malfunctioning, and I apologize for that. My name is Brian Murray. I'm a private law practitioner, a resident of Wilton, Connecticut, and I am here to comment on proposed Bill 156 and raised Bill 893. I note that my comments would also relate to a proposed substitute bill number 5310 from last week and the biometric privacy bill of a few weeks ago, whose number I don't have available. First, I'd like to say I've never done this before, so any errors I'm making in protocol or nomenclature, I apologize for in advance. All right, so my comment is basically a simple one, and it follows up on something Representative Winkler briefly mentioned, or more than briefly, but it's the need for a private cause of action in these consumer data privacy breach cases. As Representative Winkler pointed out, there may be cases where the state of Connecticut just doesn't have the time or the resources to follow up, in which case the consumers would then be out of luck. The addition of a private right of action provides an additional deterrent to what we in my business call the bad actors in this case, the people who allow the data breaches to occur, as well as people who breach their data. But the additional deterrent, I don't think, can be underestimated. The recoveries in private actions can run into the 9 figures. For instance, in the Yahoo data breach case, the recovery was over $100 million. And I'm going to use the Yahoo case as a segue into another reason why you need a private cause of action. I believe somebody testified that there are 3 powerful but mighty lawyers in the AG's office who will be tasked with enforcing this. And I'm sure they're tremendous and the hardest and greatest workers that the state has. But there is absolutely no way that I think anybody can say with a straight face that 3 lawyers can possibly police all the data breaches and produce a recovery for the state. And there's no recovery for the consumers of Connecticut, as was pointed out. The recovery goes into the state coffers. But 3 people working 24/7 can't possibly cover all the grounds they need to cover. The Yahoo case alone probably required, and I didn't go to count it up, and I'm greatly underestimating since I didn't go back and count. There was at least 10 law firms involved and at least 50 individual lawyers on that one case alone. The thought that 3 lawyers are going to provide adequate coverage for the state of Connecticut, quite frankly, is just ludicrous. Without the additional, what we call private attorney generals policing this, it's just not going to be policed. And I don't think there's any way somebody can say it is. I believe it was Ms. Lubin raised the traditional boogeyman of meritless lawsuits And that's why you don't need a private cause of action. There's nothing meritless about these lawsuits at all. If you look at any of the data breach cases, Yahoo, Equifax, Facebook, they've admitted the data breach occurred. It's really just a question of there not being an adequate law to provide for it. They're trying to fit what's obviously tortious action on behalf of these people who allowed their data to be breached and caused harm to the people of Connecticut into, tort laws that go back, to, the cases we read in law school, in re anonymous from 400 years ago. I mean, tort law from the 1600s is not really adequate to
excuse me, Mr. Murray, just a heads up, we're past the 3-minute marker.
Sure. So I'll wrap it up. We need a modern law to cover modern tort causes of action, and trying to shoehorn this into case law and common law from 300-400 years ago, et cetera, doesn't work. And there really needs to be a private cause of action to put some teeth into this and provide a recovery for the people of the state of Connecticut, as well as other states. But right now, everybody on this call is concerned with the people of the state of Connecticut. And I'll finish there.
Great. Thank you, Mr. Murray. Senator Kissel, followed by Representative Winkler.
Thank you very much, Mr. Chairman. Hi, Mr. Murray. I'm trying to, I don't really understand. Do you like the bill or not like the bill? You heard the testimony, I'm guessing, from the folks from the Attorney General's office, but then there was also this counter testimony, somewhat counter, not totally, from the New England Telephone, something like New England Cable and
Telephone Association.
Yeah, there we go. That said, don't change anything. And so I'm just wondering, who do you advocate for? Are you just independent? And what do you think about the bill that's before us?
Sure. The bill that's before you is fine as far as it goes. What I'm saying is it just doesn't go far enough. It needs a private cause of action to allow the people of Connecticut to pursue remedies in cases where the Attorney General doesn't have the time or the interest in pursuing a remedy in any particular case. And in addition, whatever remedy the state of Connecticut is interested in will not result in any recovery to an individual. So I like the law as far as it goes. I'm saying it doesn't go far enough. It needs a private cause of action for individuals, and especially on a class basis.
Yeah, and are you just here as a private individual, or do you represent an organization?
I do not represent any organization here today. I'm here as like I said, a lawyer and a resident of Connecticut.
So one of the recommendations from Nicole and Michelle were a CUTPA provision, which would allow, based upon my legal background from 1984, people to act as private attorney generals and seek attorney's fees and damages. Would you support that kind of provision?
Absolutely.
Okay, thank you, Mr. Chairman.
Thank you very much, Senator Kissel. Representative Winkler.
Yes, thank you for your testimony. Is there any model legislation out there, or did any state get it right?
Well, I mean, I'm going to be completely honest. I've not looked at the other states' laws. I've not examined anything for proposed language, et cetera. Like I said, I've never done this before. So my son, who is just extremely interested in Connecticut government matters, brought this to my attention and said, you have an opportunity to testify if you want. So I did, but I have not come prepared with any other proposed language.
Would you support a cause of action in anything other than data breaches?
I'm not sure exactly what you're asking. I mean, I support a private cause of action for consumers in any case where they're injured, whether it's a data breach or not.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Winkler. one other suggestion that was brought before us was to eliminate the cure period. Currently, there's a 30-day cure period in this, the law as it's drafted. Can you comment on that? And again, you may not be prepared to comment on that. You may have not have considered that.
To be honest, I have not considered that cure provision, so I really have no comment on it at this time.
Okay. And then with that, I applaud your son for his interest and would encourage him, to reach out to us as well. We always like to talk directly to students. I'm not sure what age student he is, but we'd love to get his input as well. So please encourage him to reach out to us.
Actually, well, he's no longer a student. He just graduated from college, but he did actually testify before some committee on Monday. I'm not sure which one it was. So he's
great.
Quite interested in this stuff.
Yeah. So please have him reach out. I'd love to see if if he has any questions or any way we can help mentor him. So thank you very much, Mr. Murray, for coming before us today.
You're welcome.
Okay. With that, Mr. Clerk, I believe the next person to testify is Sean Jeffrey.
Yes, and he's coming in now.
Okay, great. Thank you.
Mhm.
Hello there. Can everybody hear me okay?
Yes, we can. Please proceed, Dr. Jeffrey.
Excellent. Thank you. Thank you, Chairman Maroney and distinguished members of the committee. I appreciate all of you staying to the end. I am the last person between you, a biology break, and lunch, so I'll try to make my remarks as succinct as possible. So I'm Sean Jeffrey, and I'm speaking to you today about SB 895 and my written testimony regarding SB 694. I'm the Director of Pharmacy at Harvard Healthcare's Integrated Care Partners. I also co-chair the Office of Health Strategies, Medication Reconciliation, and Polypharmacy Committee, and which we refer to as the MRPC, and I'm a trustee for the American Pharmacists Association. So let me begin by acknowledging my colleagues in health system pharmacy for their contributions in support of this legislation. I'd like to start by saying Harvard Healthcare is in support of the bill. In addition, as co-chair of the MRPC, I applaud the inclusion of definitions for deprescribing and polypharmacy. And in support of those definitions, I asked the committee to consider my written testimony where I offer some expansion to the definitions. In particular, polypharmacy is a topic that I have previously testified on before Public Health regarding the challenges of how you define it. We know what it looks like when we see it in practice. We know how challenging it can be to make meaningful changes. And therefore, I'm suggesting the committee consider an expanded definition to include polypharmacy means the use of multiple drugs by a patient, including any medication that is inappropriate or not medically necessary, such as those not indicated, not effective, or constituting a therapeutic duplication. While there's no accepted definition of polypharmacy, I believe this is reflective of clinical practice and in line with the work that the MRPC is developing. In addition to the suggested changes to polypharmacy, the MRPC also recommends expanding deprescribing to mean the systematic process of identifying and discontinuing drugs in instances in which existing or potential harms outweigh exists or potential benefits within the context of an individual's patient's care goals, current level of functioning, life expectancy, values, and preferences. And again, this is consistent with clinical practice and in line with the work that the MRPC is developing. And finally, and more towards what many of our other speakers have addressed regarding the collaborative drug therapy agreements, Harvard Healthcare encourages the committee to continue to look at these drug therapy agreements between pharmacists and physicians as an opportunity to scale and improve care delivery in Connecticut. We agree with all the previous testimony regarding the need to update the CDT agreements. And I want to provide some additional context. I practice at Integrated Care Partners, where I work with Harvard Healthcare's medical group that consists of thousands of practitioners. We strive to deliver pharmacy population health management, yet are hampered by these outdated and restrictive collaborative drug therapy protocols that require one pharmacist and one physician agreements. And as one of Connecticut's largest health systems, we're interested in unlocking the potential of our pharmacists to practice in a truly integrated care manner. So it's time for Connecticut to join other progressive states in updating our collaborative drug therapy statutes. With DCP's leadership, in collaboration with my colleagues in pharmacy and medicine, we can improve collaborative drug therapy agreements to reflect best practices, remove administrative burdens, capitalize on the technology advances of EMRs, and improve patient outcomes and safety. So thank you for your time and attention in support of SB 895 and 694. And I believe I'm actually finishing on time.
Good job. Nice succinct testimony on right there under the gun. It appears Senator Austin has a question. Senator Austin?
Thank you very much. Thank you very much for coming on. I'm just curious, how many other states have updated their rules relative to this, and which ones are they?
So this is a continuous process whereby states are involving their pharmacists across practice settings, working with medical societies to update collaborative practice agreements as changes evolve with medicine. So it's not a static thing. This is a dynamic process across states. So I don't have an exact number of how many have been updated. I would suggest that there's quite a few that have been continually updated. Some states that I could point you to would be the state of Washington, the state of Iowa, that are sort of exemplars in this area of how they've been able to really revolutionize some of the practice opportunities for pharmacists. And to an earlier comment that was made by one of the speakers, it may have been you, Senator Maroney, about workforce development and people coming into the state. We want to make sure that the pharmacists that graduate from our state have the best opportunities possible. So this is another reason to think about ways that we can expand and further elaborate what these collaborative drug therapy agreements offer.
So in addition to other states, and you've given us a couple, is this something that Connecticut doesn't do well, doesn't do at all, or is far behind other states?
So I'll be frank, I think we were earlier to start some of the collaborative drug therapy agreements, but it's been stagnated. And now that our platforms and our systems have evolved and we become so much more integrated in the care that we deliver, literally at Integrated Care Partners, right? We have an opportunity to unleash a workforce that is being held back and to create new job opportunities for pharmacists here in Connecticut. So there is a need to go back and revisit the language that was originally put forward, I think, probably in the 90s. I know my colleagues that worked on that were very passionate about it and continue to be passionate about ways that we can not just make the little incremental changes, but think broadly about what we can do here with these agreements. And yes, what we have before us is an important first step. There's a lot more that we can do.
I'm sorry to continue to ask questions, Mr. Chairman, but one last question. What would be the recommended next 2 or 3 steps? And that would be my final question. Thank you, Mr. Chair.
Well, thank you, Senator Austin. I think what would be helpful is to bring the stakeholders together that, my colleagues, as I mentioned, in pharmacy, medicine, at DCP, public health, and think broadly about where are there opportunities for us to collaborate so that this becomes a win-win for the citizens of Connecticut that allows us to opportunize the advances that we have already existing, that we can look at what other states have been doing, where there's evidence that shows that these agreements have actually had the clinical outcomes that we're after. And I would also say, draw upon things that are already working in Connecticut. I used to practice at VA Connecticut for 15 years. And within the VA system, they've been doing this type of stuff for decades. So it's not like it's revolutionary. We just need to bring the general practice here in Connecticut beyond where it's stagnated.
Thank you.
Thank you.
Thank you, Senator Austin. And you can ask as many questions as you want. You always add value. So thank you. Dr. Jeffrey, I guess, again, this isn't, we're not looking at this under this bill, but you did raise an issue. So I just want to understand it a little better for myself. so you say that the agreement, the way it's written now, agreements have to be between an individual pharmacist and an individual doctor, as opposed to, let's say, again, in my area of the state, Northeast Medical Group is probably, the largest, right? The most doctors here. So I guess what you would suggest is that a group could have that agreement. So like Northeast Medical Group, where you would have a number of doctors, or am I misinterpreting?
No, I think you're interpreting that correctly. As Dr. Luana had mentioned, what they were trying to do around the work for anticoagulation, it becomes cumbersome. They're focused on just a specific condition. They are then having to build these agreements with the providers in that practice. So there's an administrative burden to trying to scale that if you wanted to take a population health approach and say, let's look about how we can engage pharmacists in co-managing diabetic patients, as she was alluding to. So for Hartford Healthcare to be able to have a blanket agreement that would cover the system and allow the pharmacist to then, within their scope, within what is defined, practice up to the top of their license, that makes it a lot easier for everybody. It's less administrative burden for sure.
It sounds just like eliminating that 30-day requirement. It sounds like it may be just
Exactly.
another requirement that at the time this law was written, we didn't have as many large systems, right? That
Well, we
there
didn't
were
have
more
large
individual
systems.
practices.
Yeah, we didn't have large systems. We also didn't have integrated
EMRs.
electronic medical records.
And that is another question I have on the EMRs, because I know they don't all necessarily speak with each other, right? And that, which brings up, so, there is the potential that, because the systems, the way they've evolved, you may have a cardiologist you like, but your primary care may be under Northeast Medical Group, but perhaps, and again, I probably shouldn't use names, but let's say under one large group, whereas your primary care is under one group. Is it possible then that you have a cardiologist who has prescribed your blood pressure medication that's under another group, that they're not on the same EMRs?
It's possible, but it's increasingly less likely here in Connecticut, as most of the health systems, the large ones, have adopted the same EMR company platform in Epic. So it allows us to communicate between Hartford and Yale and other systems in UConn, et cetera. So we can see that information, and it helps to inform our clinical decision-making, and it helps with the communication back and forth when there is a provider that's outside of network, if you will.
And that was, I guess, what I was thinking, is that the pharmacist then would see full, right? Yeah, I mean, you would have to see all of the notes, and
Yes.
So you could potentially know if, wait a second, this may interact with another medication that you just weren't aware of because of, for whatever reason. I mean, I think it was, for whatever reasons, the systems weren't as interoperable initially. And I know everything is improving, and we want, more fluid communication, but.
It also gives us a chance to leverage the data that is collected. And I know there's a lot of other data discussions that you had today, but
right.
You think about what we have here at Integrated Care Partners. We're managing a population of several 100,000 residents here in Connecticut, and we have medication information on that. And if we had protocols in place that would allow us at a population level to then be able to, let's say, act on some of that information in a more robust way, we might be able to head off potential problems before they begin. And again, preventing harm is one of the first things that we want to try to do in pharmacy.
Right. No, thank you. You raised a good point. Again, it's not, the data privacy was a separate, but that, we are well situated as a state, I think, as health tech, in terms of we have, our large hospital systems, but also Jackson Labs, Alexion, the pharmaceutical companies that if we can work together and sharing that data and using it to drive the health of populations. So we want to make sure that we're not restricting that flow of data, but while protecting the privacy of the individuals. So,
yeah.
Are there any other questions for Dr. Jeffrey? Okay, seeing none, thank you very much for taking the time to come testify before us today.
Thank you.
Mr. Clerk, is there anyone else who's not on our list of speakers?
And with that, that's it.
No, and I believe this is the last public hearing for general law. So I just wanted to take a moment to thank our clerk, to thank Sam Clark for his work as a clerk. I think he's done a great job, and it is difficult for all. This is new for all clerks, the electronic public hearings, but in addition to this being new, he is a new clerk as well. And so he's done a fantastic job. And I've heard that from a number of people. So I just wanted to thank you for your work.
Thank you.
And
Maybe he should conduct a training.
Thanks for that suggestion, Representative Winkler. So I think I did see a couple other people who seem to be echoing the sentiments that we really appreciate that work. And with that, I think, unless Representative Vitigliano, do you have any comments?
Thank you for your time, and also congratulate Sam on a job well done.
Great, thank you. So thank you, everyone. With that, we are adjourned. Have a great day. Oh, and our next meeting, actually, Mr. Clerk, before we adjourn, time and date of the next meeting.
So the day is going to be next Tuesday, March 2nd. The time I will let you know as soon as we get that finalized.
Okay, great. So if members could please hold March 2nd, and we will be, I believe we will be looking to JF some of the concepts, some of the bills. So thank you very much. And with that, we are adjourned.